Item number 39, the last item, if you will please.
Yes.
This matter has been substantially heard by court number 8 now. Honorable Justice P.J. Soikia.
Okay.
So 2 occasions the Honorable Court has substantially heard the matter. So
Okay.
can it be possible to?
Item number 39.
39.
Heard Mr. B. Datta, Learned Senior Counsel, appearing for the criminal petitioner
Yes.
Who submits that this matter, which is listed today in the hearing column, has been substantially heard by a coordinate bench of this court on 2 occasions. Coordinate bench of this court within bracket, Honorable Mr. Justice P.J. Soikia, bracket close. Hence, he submits that it would be appropriate that this matter may be listed before the said court. The prayer is allowed, registry to do the needful.
Is it possible to fix a date?
No.
Yes. There is a difficulty. Yes.
Different court.
Yes. I understand.
Registry.
Yes, I understand. The interim order.
The interim order shall continue till next day.
It is also item number 47. The IA for modification of the bail order also. It's a new matter also yet to be heard also. So this is the IA reference, it is listed for orders. May I fail also, it may be taken up at last motion item also. I have some personal agency also. As last motion item also. Very new press matter also. Item number 47.
Okay.
Last motion.
Okay.
Okay.
May I please, Lordship, I beg to mention item number 17, Lordship, 17. Lordship, C is not dear, Lordship. I am on interim, Lordship.
Heard Miss
M. Deca.
M. Deca, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed on 29th of August. The interim order shall continue till next day.
These are Lordship. Lordship, I beg to mention AG number 1605 of 2025. This matter is pending for adjudication, Lordship. Yeah, today, Lordship, item number 30 has been listed. So may I pray that this matter also come up in the production list and take up before Lordship rises. Little urgency, Lordship.
No, it relates to the same.
And diary also.
Okay.
With regard to another prayer, Lordship, with regard to item 41, I'm not pressing that application. Supplementary release.
Item number 41. Heard Miss T. Som, Learned Counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This application is dismissed on withdrawal.
Item number 24, Lordship. Hearing column, Lordship, adjournment for today, Lordship. Item number 24.
Heard Mr. F. Hawk, Learned Counsel for the petitioner, who seeks an adjournment on the ground of personal difficulty. You are on interim. Case diary is there. The short date. 13. The prayer is allowed. Let this case be listed on 13th August. The case diary which is available shall be retained till next day.
If you have I pray for listing upon regular bail application merit for motion merit, if possible.
When have you filed?
Yesterday.
You have to wait for tomorrow.
Tomorrow I'm saying.
It will be automatically listed. If it does not get listed, you may make mention.
Your Lordship, I like to mention for withdrawal.
When? Tomorrow. Tomorrow. Give the mention memo.
May I please, Lordship, item number 43 of supplementary release, Lordship. The agenda matter for a day lordship.
43.
Not given, lordship.
43, you have informed the petitioner? Okay. Heard Miss N. Kakoti, learned counsel for Customs Department, who prays for an adjournment. As necessary instructions have not yet been received from the respondent side. Learned counsel for the petitioner does not opposes the prayer. Hence the prayer is allowed. Let this case be listed when 19th of August.
55.
Okay, 25th of,
It is
26th of August. Yes,
Wait, Lordship, I beg to mention item number 36. Lordship, in this matter, case that was called for, but case that was not arrived. 36.
36 hearing matter.
Lordship, the case that was not arrived.
Case diary was called for. We'll pass orders when the matter is called. If it reaches, we'll pass order then.
May I please? I beg to mention for some accommodation regarding the item number 19. Maybe taken up at 2. I left my file in my chamber. I have to go chamber this 2.
Okay.
19, maybe at 2.
Not at 2 in the second half.
I want to mention regarding item number 2 of daily list, matter may be adjourned for the day lordship.
Why?
Learned counsel, Mr. Jain, Lashkar is not feeling well, lordship. So,
Heard Miss J. Ghosh, learned counsel for the petitioner, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed in the next week or on a date to be fixed by registry.
much of it.
Lordship, item number 45, Lordship. Lordship, your Lordship was pleased to keep the matter for reports and on 18.
What is your submission?
Lordship, submission is that it's supposed to come for motion, Lordship.
Why motion?
It has come for bail hearing, Lordship. Item number 45, only notice to the private respondent. Lordship already called for reports. and
Yes,
it
we'll
is-
take it up at 2.
Item number 17, just now petitioner has mentioned it, that we got the file already substituted, madam. So that order may not be, I'll call the.
Item number 17.
17, already date has been given for case diary, madam. Boysalang PS, madam.
Okay,
That
that is
is
it.
already substituted, madam. That's just,
You inform the council. We'll take it up.
Item 44, Withdrawal.
Yes,
Lordship, on the request of the petitioner, the request of the,
but your name is not there in the
my name is there, PK Das.
item number 44. Key 40.
42.
Oh, 40, okay. Heard Mr. P.K. Das, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This case is dismissed on withdrawal.
Daily list, motion ID, item
Right.
number 1. May I please, your Lordship. Lordship, in this matter, Lordship, one CM vigilance case was going on, Lordship. After that, thorough investigation was done. And then the officer in charge filed one FIR dated 07/01/2025 under section.
Where is the special PP? You inform them. We'll take it up. There are two special PPs. Any one of them, let them come. We'll take it up after some time.
Updated item 47.
It's a IA for modification of a bail order. The bail order is on page number 10. So order dated 28/5/2025. And I am seeking modification of the that is contained in para number 16, which is page number 13. Okay, I was granted bail, Lordship, with a condition that on the furnishing of a bail bond of ₹2 lakhs and with
Para,
para 16,
page,
page number 13, Lordship. Of my ILS. Page number 13, para 16 of the bail order.
yes.
Here, Lordship, I was allowed to go on bail, on furnishing a bail bond of ₹2 lakh and with 2 local securities and each of like amount, both of which should be permanent resident of district Bazarisra. Subsequently, I have filed one IA. It was changed to district Sribhumi. Bazarisra was the police station. Now, Lordship, there was another IA, that was correction was done, Lordship. Now, Lordship, I am Lordship a resident of Guwahati, Lordship, and I am finding it very difficult to find.
Under what provision this IA has been filed? There must be some provision of law which enables to modify.
There is
You answer my query. We'll take it up at 2. You are, under what provision you have filed this IA?
At 12 also, I'll try to.
Okay, at 12.
Bail hearing day, item 3 and 4.
The CD not available. Matlab, earlier actually official report was not available because of the official report was called for with updated CD.
Earlier, my lord, on 7 occasions, this matter has been listed for bail hearing. And my lord, and CD was available on several occasions, but FSL was not there. So my lord, FSL has been called for, but today CD and FSL. both
Why
are not
FSL
available.
is required in such matters?
Commercial one.
No. FSL will help who? Whether the petitioner paid for FSL or the prosecution side.
Yes, official is required for trial, actually.
No, suppose FSL comes in negative, it will help the accused. Otherwise, we may assume that
See, Matlab,
Is positive.
that assumption also cannot be made. Okay, let us wait. When can you produce the?
what is your case?
My lord, it may come in the, my lord, 2nd of September. By then, my lord, the statutory period will also be over, my lord. Let it come up.
Heard Mr. K. Barua. Learned,
This week.
sorry, sir. Heard Mr. U.J. Soikia, learned counsel for the petitioner. Both 3 and 4 common order. Learned additional public process, also heard Mr. K. K. Parashar, learned additional public prosecutor, who submits that up-to-date case diary is not available, and hence he prays for some more time for producing an updated case diary. Prayer is allowed. When?
2nd of September, my lord.
Second of September, why you need to come to this court? You can go to that court. we'll fix before that, 20, okay, 2nd of September. Let it be on 2nd of September.
Item 5,
My it's a regular bail application. The chartered case, my lord. Trial is going on, my lord. My lord, now he is behind the bond of 1 year, 7 months, my lord. My lord, there is a total 2 number 8%, my lord. Out of 2, my lord, 1 already granted bail, my lord. My lord, may I submit the on the ground, my lord, at the time of arrest, my lord, no ground has been mentioned in the notice and for to the petitioner as well as the relative of the petitioner, my lord.
On what ground you are seeking bail?
That 47 as well as the 57, my lord. The ground has been not mentioned in the notice as well as my lord, forwarded to the petitioner and as well as my lord, to the relative of the petitioner, my lord. That is the main ground, my lord. The valid the article 2020, my lord.
Yes. It's not there. Heard Mr. S. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Gautam Kumar, who has been detained behind the bars since, what is the date of your arrest?
9
Since
1
9/1/2024, within bracket, for more than 1 year, 1 year, 7 months, bracket close, in connection with NDPS case number 18/2024 under sections 20B2C/29 of the NDPS Act 1985. List of accusation, quote para 3 from bail application number 1611. It is in the record. Flag করে দিছো সাইলবো। Quote para 5. In place of her, his লিখিব। অলপ changes কৰিব লাগিব। Quote para 6. However, 6 তে add কৰিব এটা line. However, learned additional public prosecutor has fairly submitted that in this case, in the notice issued to, in this case, no grounds of arrest, where you have received the notice under 47.
No.
You have not even,
Yes. Not
there is no notice.
Yes.
Oh yes, notice was there. Is Putul, to record the auction, Sharma. Here. Code para 7. Code para 8. Code para 9. 50,000 with 2 sureties of like amount. PG blank ase, whether notice is there. 47 notice is not there. Is there? Okay. Though the blank G asile, though the petitioner was served with a notice under section 50 of the Code of Criminal Procedure 1973 when he was arrested, however, the said notice does not mention any ground of arrest therein, apart from the police station case number as well as penal provision. Stop. Baki as it is. 50,000 with 2 sureties.
Item 6.
Your Lordship, on the last occasion, the present status of the court of the case was, Your Lordship, inquire about Your Lordship. So it's supposed to.
There in the record, so it has been received. Already, Lordship, the evidence of the prosecution, the PW has been closed, Lordship.
Close.
Closed, and now it is fixed for statement of defense on 29/7.
Was there,
What's
now,
fixed for statement of defense?
now it is on Your Lordship, 12/8/2025, Your Lordship. Next day.
For argument. Lordship, it is already fixed for argument.
12/8 is for argument.
I pray Your Lordship till that day also, Your Lordship.
No, you pray before the trial court.
Yes, Your Lordship. I made prayer, Your Lordship. On the last occasion, prayer was not done. Your Lordship, otherwise several bail petition where Your Lordship preferred, Your Lordship, that have been rejected, Your Lordship. I have annexed all those orders. Your Lordship will find it page 34, Your Lordship, the last one.
What is the accusation?
Your Lordship will find at page 23, Your Lordship, POCSO, Your Lordship. The charges were framed under section 137(2)/65 of BNS and section 6 of POCSO 80, Your Lordship.
And what is your submission?
Sufficiently, Your Lordship, since all the prosecution witness, the evidence.
But the trial is at the,
Back at Your Lordship. That is true, Your
let the trial finish. Trial will get over.
Lordship. There is no chance of influencing the witnesses now, Your Lordship. Your Lordship.
But if
Moreover,
there are
Your Lordship,
incriminating material, there is
May I
chance
pray,
of
Your Lordship?
escaping.
May I pray page 26, Your Lordship? Once that may be paid.
Not at this stage.
This is the 164 statement of the Your Lordship victim, Your Lordship.
Heard Mr. E. Ahmed. 164 statement of the victim, page
26, Your Lordship. 26 and just 5, Your Lordship.
Yes, now why to keep him? What is the reason?
Should be 164, which is but the evidence that may be taken into consideration. In our evidence process, she has clearly implicated the present victim. And even more, Lordship, all the witnesses are already overlooked.
Your Lordship, by putting any condition, Your Lordship, I'll be there, Your Lordship. If I'm convicted, I'll go definitely, I'll go inside, Your Lordship.
what she has stated in also Mr. B. Sharma, learned additional public prosecutor, as well as Mr. S. Das, learned amicus curiae appearing for respondent number 2. This application under section 483 of BNSS has been filed by the petitioner, namely Mofidul Khan, who has been detained behind the bars since 7/9/2024 in connection with sessions within bracket special case number 271/2024 under section 137 within bracket 2/65 of BNS, read with section 6 of the POCSO Act 2012. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since 7/9/2024, and the trial has already reached its culmination, as it is fixed for argument on the next date, that is on 12th of August 2025. He submits that as at present stage, there is no chance of influencing any witnesses, as they have already been examined. There is no reason for keeping the petitioner behind the bars at this stage, and hence he prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that the trial is at the fag end and the special case number 271/2024 is fixed for argument on 12/8/2025. He submits that there are sufficient incriminating evidence against the petitioner in the record, and there is a high probability of the trial ending in the conviction of the present appellant, and therefore he submits that considering the stage of the trial, the prayer for bail may be rejected at this stage. Learned, you are also opposing. What is your submission?
It's only one date remains, madam. Only the date is fixed for argument, madam. And perhaps, my lord, they have not opted for DWs also. Had their case been that like that they were reducing defense witnesses, madam, then it would have been different. But since they are not opting for defense witness, madam, and only one date remains, that is only fixed for argument. So my humble submission is that, madam, it's the best case for the trial court to decide, madam. If their case is good, they will be acquitted on the next or subsequent date, madam.
And,
It's a different aspect, madam.
and when have you last prayed before trial court?
So it is there, page 34, your lordship. 25/2/2025.
25?
25/2/2025, your lordship.
You should have approached.
But that, your lordship, we approach this one to court on or in the month of May, your lordship.
Stop, learned, no. Learned amicus curiae, on the other hand, also opposes the grant of bail and submits that at this stage, it should be left on the trial court to decide the case according to its merit, and as only one date, as only as the trial is pending at the last stage, the bail may not be granted at this stage. Stop. I have considered the submissions made by learned counsel for both sides. Since in this case, the trial has already reached almost its culmination, and it is fixed for argument on 12/8/2025, which is also not a very long date. This court is reluctant to grant bail at this stage, grant bail to the petitioner, considering the stage of the trial. Stop. However, it is hereby made clear that if any delay in disposal of trial occurs, any unreasonable delay in disposal of the aforesaid case occurs in this case, the petitioner may approach the trial court for praying for bail before the said court, if so advised. This bail application is accordingly dismissed.
Hello.
Item 7.
Please, sir. It is a regular bail, if you suspect case, trial is going on. My lord, here the 3 numbers down, my lord, is there, my lord. My lord, number 1, my lord, notice issued but no ground of arrest has been mentioned in the said notice, my lord. My lord, kindly see the page number 49, that is.
What is the offense?
Heroin 414 grams, my lord. Under section, my lord, 21C, public 29. My lord, now the second ground is that, my lord, that heroin, my lord, recovered from the rented room, my lord, not from my position, my lord. And third ground is that.
Is
my
it a
lord,
charge sheeted case?
yes, trial is going on. That's the case, my lord.
What is the date of your arrest?
Date of, my lord, 2 March 2024, my lord. 2 March 2024, my lord. My lord, third ground is very important, my lord. My lord,
Yes.
in this period, my lord, 1 year, 5 months, my lord, out of 11 witness, my lord, no one witness has been examined, my lord, till today, my lord. Thus it is going on, my lord. No one witness has been examined. Out of 11 witness, my lord.
Where is the notice under 47?
My lord, page number 49. Page number 49, annexure 7, my lord.
Yes. Notice is absolutely blank notice. Heard Mr. S. Rahman, learned counsel for the petitioner. Also heard Mr. D. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Munnes Khan, who has been detained behind the bars since 2/3/2024 in connection with NDPS case number 272/2024 under section 21C/29 of the NDPS Act 1985. pending before the Court of London, Additional Sessions Judge number 5, Kamrup Metro, Guwahati. The list of, where is the affair?
Case number 14, ma'am.
The gist of accusation in this case is that on 3/3/2024, one Vishal Gorshai, SI of police, had lodged an FIR before the officer in charge of STF police station, inter alia, alleging that on receipt of an information through reliable sources that the accused persons named in the FIR, including the present petitioner, have kept huge quantity of suspected narcotic drugs in their rented premises at Prajyotish Nagar under Jalukbari police station, a search team was constituted, full stop. During search operation in the rented premises of the present petitioner, 34 numbers of soap boxes containing suspected heroin weighing about 414 grams were recovered therefrom. Stop. Learned counsel for the petitioner has submitted that the petitioner is not involved in this case, as nothing was rented premises is yours. You are denying.
Honors name alert is separate.
As nothing was recovered from his possession, and the premises from where the seized contraband was recovered does not belong to him. He has also submitted that the petitioner has been detained behind the bars for last 1 year, 5 months. However, till date, not even a single prosecution witness has been examined. Stop. Learned counsel for the petitioner has submitted that the main ground which the petitioner is pressing in this case for his bail is that though the notice under section 50 of BNSS was served on him, however, it does not contain any grounds of his arrest, and therefore he submits his constitutional right behind his constitutional rights guaranteed under Article 22(1) of the Constitution of India has been violated in this case. Citing, you are relying on which case? You are not relying on any. Stop. On the other hand, learned additional public prosecutor has submitted that though there are incriminating materials against the petitioner on record, however, he fairly submits that in this case, the notice under section 50 CRPC, which was served on the petitioner at the time of his arrest, does not contain any ground of arrest. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of NDPS case number 272/2024. It is apparent from record that the notice under section 50 of the Code of Criminal Procedure 1973, which was served on the petitioner on the date of his arrest, that is what is the date of your arrest?
2nd March 2024.
Date of his arrest, comma, does not contain any grounds of arrest. No basic facts have been mentioned, no basic facts which necessitated the arrest of the petitioner in the aforesaid case have been mentioned therein. Stop. It also appears that apart from the police station case number as well as penal provisions involved in the case, no other information pertaining to grounds of the arrest of the petitioner were stated in the said notice. And therefore, this court is of the view that there has been violation of the constitutional mandate under mandate of communicating the grounds of arrest, comma, in writing, comma, to an arrestee at the time of his arrest. Stop. In the case of Vihan Kumar versus State of Haryana and another reported in 2025, 5 SCC 799, the Apex Court has observed that in the event of violation of fundamental rights of an arrestee guaranteed under Article 22 within bracket 1 of the Constitution of India of providing grounds of arrest to such an arrestee in writing, the arrest itself gets vitiated, and on that count only such an arrestee may be granted bail. Stop. In the instant case also, there has been violation of the fundamental rights of the petitioner, guaranteed to him under Article 22 within bracket 1 of the Constitution of India, which in the considered opinion of this court overrides the embargo section 37 of the NDPS Act. Stop. For aforesaid reasons, the petitioner is entitled to get bail in this case. The petitioner is therefore, above named petitioner is accordingly allowed to go on bail of rupees 2 lakhs with 2 sureties of like amount, subject to the satisfaction of the trial court with following trial conditions. This.
1 lakh, 2 lakh.
No, the quantity of contraband here is too much.
Item 8.
Well,
Wait, please, Your Lord. Here, my lord, the petitioner,
Bharata Teta Matilon at 12. Yes,
here, my the petitioner was initially arrested, my lord, on my lord 7/1/25, 07/01/25, in relation to a case, my lord, of Salmara PS case number 4/25. Kindly, lordship, note down the date, my lord, 07/01/25.
yes.
He was arrested in a Salmara PS case number 04/25. My lord, while he was in custody, my lord, a summon has been issued to his home, my lord, that your lordship will find at page 25, my lord. Page 25 is the summon, my lord, with regard to special and case number 0625, where he has been shown as an absconder, my lord.
Yes,
Now, my lord, lordship will turn to my lord page 21, my lord. The orders of the court, my lord. My lord, accused Mojammil Haq, I am not Mojammil, my lord, second line, my lord. Accused Mojammil Haq is not produced from jail Hajor. Issue fresh production warrant against the said accused, my lord. My lord, the next page, my lord. Lordship turn page 23, my lord, the handwritten, my lord. Accused Mojammil Haq is produced through VC and he is remanded till 19/4. There is the other accused. So me, my lord, accused Mojammil Haq is produced physically and remanded till 19/4/25, issue custody warrant. So therefore, remand, my lord, it amounts to arrest in the present case, my lord.
remand does not amount to arrest.
My lord, paragraph 17, my lord.
Yes,
I had only one book, but that's
paragraph
17, 17, my lord.
No, you may read it. Let me hear.
Fine.
And you may emphasize
Fine,
on
fine.
which you are relying. What is the citation?
Citation, my lord. 2024 10 SCC, page 336. 2024 10 SCC, page 336.
What is?
Parties, my lord, Dhanraj Aswani versus Amar S. Mulchan. This case, my lord, earlier I had relied upon, my lord, whether anticipatory bail application is whether when a person is behind the bars, whether he can file anticipatory bail in another case on.
Yes, he can file.
That case, my lord. This is the case, my lord. So here, my lord, paragraph 17, it says, my lord, in Sanjeev Kumar versus State of Odisha, a learned single judge of the High Court of Odisha took the view that there is no statutory bar for an accused in custody in connection with a case to pray for grant of anticipatory bail in a different case registered against him. The court, upon perusal of the relevant provision, took the view that arrest means physical confinement of a person with or without the order of the court. The court noted that Section 167(2) CRPC, which governs remand, is applicable to a case where the accused is already arrested and the charge sheet has not been filed. The court observed that there is no specific provision in CRPC which governs a situation where a person is required to be arrested / remanded in connection with a new case where he is already in custody in connection with some other case. In such a situation, the accused can only be remanded in connection with the new case on the order of the competent court. Answering the question whether such order of remand by the court can be equated with an act of arrest, the court held that the purpose of remand, as in the case of arrest, is to collect evidence during investigation, and thus both amounts to one and same.
No, but in this case, the custody warrant was issued
Yes,
during trial stage,
yes, ma'am.
not at the investigation stage.
Not at the investigation stage. So, as I am behind the bars in relation to another case, so the court below, my lord, rightly, my lord, issued production warrant. And according the jail authority produced me before the court. And my lord, on 11/4, my lord, the court issued custody warrant. Now the question arises, my lord, I was therefore in the new case, I got arrested. my lord. Now the question arises, my lord, whether section 47 and 48 of the BNSS.
Is applicable to such cases.
Yes, my lord. And so far, my lord, section 47, my lord, it says, my lord, if a person is arrested without a warrant. If a lordship says, my lord, 47. But the warrant is there, my lord, every police officer or other persons arresting any person without warrant shall forthwith communicate to him with full particulars of the offense for which he is arrested or other grounds for such arrest.
So what is your submission?
My submission, my lord, so for 47, my lord, I am skipping, my lord, because more or less it is a warrant, my lord. However, in the apex court has held, my lord, in the case of my lord, that Keshi Upendra Reddy, my lord, it specifically states in paragraph 36, my lord.
What it say?
Keshi Reddy, Upendra Reddy versus state of Andhra Pradesh.
What is the citation?
Citation, my lord, I don't have, my lord, I have the case number, I'll submit.
What it states?
My lord, paragraph 36, my lord. If a person is arrested on a warrant, the ground for reason for the warrant is the ground for reasons for the arrest is the warrant itself. If the warrant is read over to him, that is sufficient compliance with the requirement that he should be informed of the grounds of his arrest. If he is arrested without a warrant, he must be told. So in the case, my lord, assuming, my lord, he is arrested on a production warrant, my lord, the jailer will say, these are the grounds you have been arrested. Or you will be produced before the court. But on the LCR, my lord, the trial court records, nothing is there, my lord. So and for the moment, my lord, I am skipping 47, my lord. Now, if a lordship goes to 48, my lord, it says, my lord, every police officer or, my lord, other person making any arrest under this Sanhita shall forthwith give the information regarding such arrest, place where the arrested accused person is being held to any of his relatives, my lord. So whether, I think, my lord, this notice is mandatory, my lord.
Even when court,
Yes, my lord. Because I am behind the bars.
because this is applicable to police officer or other person,
Other person.
whether court is included
I
within
think, my
the.
lord, the juristic person, my lord, the court will be there, my lord, other person. My submission is that, my lord. Because my relative should, my family member should know. Because I'm in case number 1, suppose, my lord, I was arrested, that they know. Subsequently, in another case, suppose it is case number 2, my lord, they should have the knowledge, my lord. And in the instant case, my lord, the earlier case, my lord, I got bail back from this court.
Now you are detained behind the bars in this case only.
Yes, my lord. Since 11/4, my lord. The question is that, my lord, whether notice is required, my lord.
Okay.
Well, I have gone through, my lord, I have.
Could you find any authority?
But that's why, well, I have find, my lord, any authority, my lord, regarding this. I think this will be the first in nature, my lord.
Remand is under what provision?
My lord, that the citation I relied upon, my lord. Second. Is 325.
Yes, yes, Mr.
Matlab, that aspect I have to be examined, matlab, sometime regarding stone arrest and this, regarding this.
No, his main submission is that
what
even
he-
if when court remands,
what it is.
court uh, first of all allows production of a accused who is already detained behind the bar in a different case. And thereafter, when it remands, he is saying that it is required to give 48 notice. What is your submission?
Matlab, that aspect, matlab, regarding, to inform the.
Let him answer. It is NDPS case.
NDPS.
Otherwise, embargo of 37 is there.
Yes, but the co-accused had granted bail by this court, by the court below, on the ground of non-furnishing of the grounds.
But his situation must have been different from yours.
No, my lord. In fact, my lord, the contraband was seized from the possession of the other accused and from his house. And my allegation is that, my lord, in the FIR, my lord, I was in the house when the police came, I ran away. That is the only allegation. And moreover, my lord, I am a physically disabled person. Now, your lordship will see, my lord, the
Okay,
court
okay.
below.
His basic submission is that even if a person is detained behind the bars on the orders of the court, remand orders of the court, yes, notice under section 48 is necessary or not. Let him answer.
Yes, but only paragraph page 40 for a once, the court below, what the court below has opined, my lord. Page 45. And admittedly, the accused shown as absconder in the charge sheet, and he was detained in connection with the case, who was physically produced of his on the strength of production warrant issued against him. The question of serving notice by the arresting authority is not attracted in the present case. However, the accused represented all along with his engaged counsel due to non-appearance of the accused, the disposal of the nothing has been stated with regard to the production.
Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Tozammil Haq, alias Tozammil Haq, who has been detained behind the bars since 11/4/2025 in connection with special within bracket N case number 6/2025 corresponding to South Salmara Police Station case number 143/2025. Stop. Learned counsel for the petitioner has submitted that the petitioner was initially arrested in connection with South Salmara PS case number 4/2025 on 7/1/2025. And while he was detained behind the bars, the trial court in case numbers in special and case number 6/2025 issued production warrant for his production in the said case. And accordingly, he was produced on
11/25.
11/4/2025. Learned counsel for the petitioner submits that on 11/4/2025, after his production before the Court of Learned Special Judge South Salmara Mankachar, he was remanded to custody till 19/4/2025. Stop. Learned counsel for the petitioner submits that the act of remanding the petitioner to custody in connection with special case number 6/2025 amounts to his arrest in the said case. Stop. He therefore submits that in such a case, the petitioner is entitled to know about the grounds of his arrest in writing. Stop. He also, learned counsel for the petitioner also submits that the relatives slash friends slash nominated person of the petitioners are also entitled to know about the grounds of arrest of the petitioner in connection with special within bracket in case number 6/2025. And notice, your submission is notice under 48 has to go.
Yes.
He also submits that notice under section 48
State one.
48 within bracket 1 of BNS S has to be issued slash served on the family members slash friends slash nominated person of the petitioner. He further submits that any violation of the same would be violation of his constitutional rights guaranteed under 21 or 22(1), Article 22(1) of the Constitution of India. In support of his submissions, learned counsel for the petitioner has relied on the ruling of the apex court. Earlier also you are relying ruling of the apex court in the case of Dhanraj Ashwani versus
Mulchan. Amar S. Mulchan. Mulchan.
versus Amar S. Mulchandni, reported in 2024 10 SCC 336, as well as the case of which other case? Reddy.
Kashi Reddy, Upendra Reddy,
Keshi Reddy Upendra Reddy versus
State of Andhra Pradesh.
State of Andhra Pradesh. Within bracket लिखिबो, judgment dated
23 May 2025.
in criminal appeal.
In criminal appeal number 2808 of 25.
Is it a judgment of apex court?
Yes.
Bracket close. On the other hand, learned additional public prosecutor has submitted that apparently the obligation under section 47 and 48 is on the police officer or other person arresting any person, and same does not appear to be applicable in case the remand is made by the order of the court. However, he submits that as the petitioner has raised a new issue, new content, raised a plea which has not been dealt with by, raised a plea in support of which he has not cited any direct authority, comma, he seeks some time to find out counter authority in this regard, and make his submissions thereafter. Stop. Wait.
Eight.
Not it. You give your so, written in so that it is clear. Eighth.
Then next week, Malad,
Okay.
I'll file a writ.
8 Divapari.
or
Okay.
at some time, Malad,
Okay.
11.
Okay. Learned, considering the submissions made by considering the contentions raised by the learned counsel for the petitioner, he is requested to give a written gist of his submissions before the next date fixed with an advance copy thereof to the learned additional public prosecutor so that he can prepare the counter to same. Let this matter be listed again on 8th of August 2025.
I'm deeply obliged.
Item 9.
নহয় dictate কৰি দিছে yes
I plead the lordship. Lordship, petition 483 application for regular bail. Lordship, I am behind the bar since 64 days. And allegation against me is level 64 of BNS and 6 of POXO. Today is fixed for CD, Lordship.
64 days
64 days.
what is the where is the FIR?
Kindly go through the actual FIR, Lordship. It is page number 12. Where is the actual FIR, Lordship?
Vernacular.
Yes.
Okay, yes.
সন্মানপূর্বক বিনীত নিবেদন এই যে আজি প্রায় 1 বছর পূর্বর পরায়
Application under section 483 of BNSS 2023 has been filed by the petitioner Ulchan Ali, who has been detained behind the bars since 1/6/2025 within bracket for last how many days?
64 days.
64 days in connection with Manipur PS case number 60/2025 under section 331 within bracket 4/64 within /64 of BNS 2023 read with section 6 of the POXO Act. The gist of accusation in this case is that on 1/6/2024, the father of the victim girl had lodged an FIR before the officer in charge of Manikpur police station, inter alia, alleging that the petitioner on pretext of having love affair with his minor rejected.
Item 12, item 47.
Read please, Lordship.
Lordship, I went for the BNSS and also CRPC, Lordship, and there is no specific provision which regard to the power of this honorable court for modification of this bail condition. However, under section 482 of the CRPC and now 528 of BNSS, this honorable court can modify the bail conditions. Although there is a provision of the 483, it is now perimeter provision of 439 of CRPC. This 483 subsection 1 clause B. Here, Honorable High Court can modify the bail condition imposed by the magistrate. But with regard to the bail condition imposed by this Honorable Court, there is no specific provision as such. However, this Honorable Court can invoke section 482 of CRPC, now 528 of BNSS. May I refer 483 of BNSS. Special here 483, earlier it was 439. Special powers of High Court or Court of Session regarding bail. A High Court or Court of Session may direct. I'm going to clause B.
You are relying on B.
That any condition imposed by a magistrate when releasing any person on bail be set aside or modified. This with regard to the condition imposed by the magistrate. Here I am on the condition imposed by this Honorable Court.
Yes.
And that can be modified by invoking 483 of CRPC, now 528 of BNSS.
That is your submission, or you have any authority?
Authority of Harvard High Court.
What it says?
Here, this was a case of Prevention of Corruption Act. Accused person was granted bail with various conditions. One of the condition was that he has to deposit his passport with a trial court. And he filed an application under section 482 of CRPC before the Honorable Allahabad High Court for modification of that bail condition. And that bail, application was opposed by the state on the ground that there is no specific.
But your interlocutory application is not under 528. The High Court, no, I understand. The High Court rules provide that you have to mention the provision of law under which an application is filed. You comply with that because
I put the provision, but since this is already we are filing it like this also. And even in this case also regarding one typographical error, I have filed one I in this case itself. And it was also allowed. This is my only submission.
no, but when I have pointed it out, law should be followed. Yes, Mr. Parashar.
Otherwise, for typographical, this is not a typographical.
This is not a typographical mistake.
Typographical mistake is just like usually file.
You amend the cause title and find out some authority apart from Allahabad. Why this court should invoke powers under 528 when you have not prayed for that?
But I'm praying, Lord.
Let it be in black and white. Let the High Court rules be followed.
But my only prayer is that it's been more than 2 months. That's it.
No, you have approached now only for modification.
My best.
No, that we will consider. If we can modify as per law, we will modify, but you have to show that this is the power.
But since this is the inherent jurisdiction, considering my submission.
No. You are not following High Court rules of mentioning the provisions under which application has been filed in this case. You amend the cause title. Mention the provision of law under which this application has been filed. Yes,
Amend first title.
or I will dismiss it.
Lordship, I'll amend that first.
Not heard Mr. Item number 47, Mr. B. Bora, learned additional public learned counsel for the applicant. Also heard Mr. A.K. Parashar, learned additional public prosecutor. This application has been filed by the petitioner for modifying one of the condition on which bail was granted to him by this court, as said condition has become onerous for him. Learned counsel for the petitioner has submitted that this court may invoke its inherent powers under Section 528 of BNSS under such circumstances to meet the ends of justice. He, however, submits that as the said provision has not been mentioned by the petitioner in the cause title of his interlocutory application, he may be allowed to file an amended cause title in this case. The prayer is allowed. When?
One thing I would like to point out, if I amend the cause title, then the nomenclature will also change. 482 petition is annually registered as criminal petition.
No, this may remain as interlocutory application. Separate criminal petition need not to be filed. The IA has interlocutory application also has to mention under what provision it has been filed. That is the requirement. Every application must.
I'll file accordingly. I will amend.
Okay. When? Let this case be listed day after tomorrow. 7.
Finding item 1.
And you also find out, are there some more authority? Which power the court is exercising while modifying the bail order?
Try to get it.
Its own bail order. While modifying it, which power it is exercising?
Try to get it.
Yes.
May I please? In this case, charge sheet has already been submitted. Next date has been fixed on 13/8/2025 for appearance.
So the anticipatory bail has become infructuous.
Sure, sir.
You
He
appear,
appear on that day.
you appear before the trial court.
Yes, special judge Assam.
Special judge will issue
Already
summons.
someone has been issued, but most probably has not received, but he can appear on
Next date is fixed on
13/8.
13/8. You have not received summons.
Not able to.
Special case number is 59/25. He as well as Manjula Chaudhary, who knows, provided.
Heard Mr. A. Mena. learned- No, there is no apprehension.
Someone has been issued.
Heard Mr. A. Mena, learned counsel for the petitioner. Also heard Mr. P. Kotoki, learned special public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Ramesh Uddin Ahmed, who is apprehending his arrest in connection with Vigilance PS case number 2/2025 under section 13 within bracket 1 within bracket small b /13 within bracket 2 1/12 of the Prevention of Corruption Act 1988. Stop. Learned Special Public Prosecutor has submitted that in this case, the charge sheet has already been laid, bearing charge sheet and laid, and a special case bearing
59 of 25.
59 of 25 has been registered in the Court of Learned Special Judge Assam, and summons have been issued to the petitioners, fixing the next date on 13/8/2025. He therefore submits that in this case, there is no apprehension of petitioner getting arrested, as the trial court has already issued summons to him. So considering the submissions made by learned special public prosecutor, there appears to be no apprehension of petitioners getting arrested in the aforesaid case as of now. Stop. This anticipatory bail application is accordingly disposed of with an observation that the petitioner may appear before the trial court on 13/8/2025 and may pray for regular bail before the said court, if so advised.
Item 10.
In this case, CD was called for. CD has not been received, but has been learned that the charge sheet was filed in this case.
Sure.
On 25/7, actually another accused, who is the prime accused, he filed a bail application. In that matter, it is in the order it is reflected that I already submitted charge sheet.
Then you pray before the trial court.
Yeah, no problem. Another accused.
But if charge sheet has been laid, you go before the trial court and pray for bail. Heard, Mr. What is your name? C. Chakraborty, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that he came to know that in this case, charge sheet has already been filed. Though learned additional public prosecutor does not have any information regarding filing of the charge sheet, however, considering the submissions made by learned counsel for the petitioner regarding filing of the charge sheet, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file an application for regular bail before the said court, if so advised.
Item 11.
Even also looked at charge sheet has not, CD has not been received.
Charge sheet has been filed.
No, CD has not been received.
Lordship, total custody is 39 days, Your Lordship. Date of arrest is 27 June, Your Lordship. FIR is page number 10, Your Lordship. 12 is relevant portion, Your Lordship. Total 39 gram suspected heroin.
39 gram.
39 with
Case diary would be.
plastic container, Your Lordship.
What was the weight of the
With
heroin?
plastic container. Your Lordship.
Otherwise, what is the weight?
Otherwise, it may be almost a small
You don't
quantity,
know.
Your Lordship.
You don't
If
know.
We deducted 30 container from the 30.
Case diary would be necessary.
Further custody may not be necessary.
Heard Mr. A.A.R. Karim, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. On the other hand, learned counsel for the petitioner submits that the petitioner has been detained behind the bars for last 39 days, and considering the period of detention, his application for bail may be allowed. Stop. In the instant case, the quantity of heroin seized is of
39 gram with plastic container.
39 gram.
Plastic
You are
container.
behind the bars for how many days?
39 days.
Okay. Is 39 grams within bracket with plastic containers. Considering the weight of the contraband,
Total container is 13 numbers.
stop.
30.
Weight of the contraband, comma, as mentioned by the learned counsel for the petitioner, comma, perusal of the case diary would be necessary. Hence, issue reminder for the same. When?
Technically on 8 Your Lordship.
No.
11 Your Lordship. Earlier already.
11.
11. Bless you.
Item 12.
Regular bail application lordship, in this case lordship the already about 54 days in custody lordship.
What is the
Offense, 12, 15 of POXO Act lordship. And
POXO.
second section, lordship.
whether notice has gone? You have taken steps.
Step has been taken lordship as of today lordship for 54 days lordship. And for a moment lordship, the
No, I will not. Whether first we have to verify whether notice has been served or.
penal section is punishment is 60 days lordship. Otherwise lordship 54 days in custody.
What is your submission?
10th of detention may be considered lordship. Otherwise lordship.
Neither the case diary is before us, nor the victim is before us. You find out through telephone.
Steps were taken in the last part of July, probably, lordship. There is an office note. Probably that is where it is.
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 2/8/2025, it appears that the service report of the notice issued to respondent number 2 has not yet been received. Stop. Learned additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of the jurisdictional police station and let this court know about the same on the next date fixed.
This is manner to the 54 days.
What is your submission? When?
Fixed
11th.
Thursday. So yes, consisting of 54 days then lordship.
Eleventh. 11th.
60 days lordship and they will be lordship and Friday lordship.
No. 11th.
60 days.
Item 14.
Also lordships, PD has not been received and also instruction of service is to be taken.
You
Paper is taken.
heard Mr. R. Chetri, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. The office note dated 2/8/2025, it shows that the service report in respect of the notice issued to respondent number 2 has not yet been received. Stop. Learned additional public prosecutor, Mr. B. Sharma, is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fixed. When? 11. list this matter on 11-8.
Item 14. DD has not been issued. Otherwise 25-1 is your arms secretary. Today is 51 days, my lord. And so far the arms act is concerned, my lord, I think it is not affected to me, my lord. The lordship comes to my lord, page 15 for a one.
Case diary would be required.
But arms act is not applicable to me.
Page,
Page 15, my lord. May I read, my lord, the brief facts of the case, my lord? The brief history of the case is that on.
what is your name?
My name is, my lord, S.L. Mangcha. Next page 16, my lord, allegation against me, my lord. Page 16, my lord, serial number 5 and 6. The alleged accused was thoroughly interrogated and the alleged accused confessed that he collected the gun license which was provided to Sri Jagat Kolita from one person named Mangkulam. Next, my lord, in the course of investigation of the case, it is established that the arrested accused acted as a broker agent of the gang running from Manipur. My lord, it is admitted, my lord, that Jagat, he came to me, my lord, to have a license. I gave the number of this Manipur person.
And 11th for case diary. Heard Mr. N.J. Daftar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. List this matter again on 11th of August.
Item 15. This will be taken after my lord.
Okay.
Published. Item 16.
Your lordship. And it is on 6/6/2025. Your lordship. 60 days in custody, your lordship. And punishment is 7 years of imprisonment, your lordship.
6/6/2000. How many days you are behind?
30 also, my lord.
60 days. Your
60 days.
page number 34. 6/6/2025.
What is the offense?
Offense is, your lordship. Sections are, your lordship. 318 clause 4, 16 clause 2, and 336 clause 3, 340 clause 2 of the NS Act 2020. Those are the two sections are 7 years of imprisonment. 318, sitting and dishonestly, indecent, deprived any property.
What is your name?
My name is
Abu Hanif Chaudhry. Yes.
My lord, this is the second round of litigation, my lord. Earlier one rejected phase.
What is the maximum statutory period?
3184 is here.
What is the punishment for 3184?
One is here, my lord. I'll check
sitting
that.
and dishonestly, indecent, delivered any property.
336 and 340.
340 is, your lordship, fraudulent and dishonestly used.
What
of
is the
court
maximum punishment? Yes, Mr. Parashar.
340. 340.
340 clause 2. Fraudulent and dishonestly used of forged documents of electronic.
What is the punishment? Okay. 336.
336 is forgery, 7 years.
Yes. He has already completed. Would be completing. Heard Miss A. Mehdi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Abu Hanif Chaudhry, who has been detained behind the bars since 6/6/2025 within bracket for last 60 days in connection with CIDPS case number 4/2025 under section 61 within bracket 2/318 within bracket 4/336 within bracket 3/340 within bracket 2 of BNSS 2023. Stop. Learned counsel for the petitioner, Ms. A. Medhi, has submitted that the petitioner has been detained behind the bars for last 60 days and all the offenses involved in this case entails maximum punishment up to 7 years only, in which case the petitioner can be detained behind the bars during investigation period only for 60 days, which he has also already completed today. Learned additional public prosecutor has produced the case diary of CIDPS case number 4/2025 and has submitted that the maximum statutory period of detention for which the petitioner can be detained is 60 days only, and he has already completed the same. Stop. Considering the submissions made by learned counsel for both the sides, and that the petitioner has completed the statutory period of detention as provided under section 487 of the BNS, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of which court?
Metro.
Learned Chief Judicial Magistrate, Kamrup Metro, with following conditions, number 1 and number 2. This bail application is accordingly disposed of. Send back the case diary.
Item 30 also same. Is counsel.
Item number 30 is there. We'll take it up after some.
42 for supplementary list. Not 42.
My lord, here, my lord, I am behind the bar, my lord. Today is, my lord, 86 days, my lord.
86.
86. It's a UAPA, my lord. The allegation is that we are linked with the Alpha I cadres, my lord. And the other two accused has been granted bail by this court, my lord.
Yesterday, my lord,
Okay, what is your name?
My name is Ranjan Gankhwa.
one is rejected also yesterday, my lord, and 3 allowed.
The recruiting person who was recruiting was,
That was rejected. by
and those who were recruited were allowed.
those are allowed. This person, my lord, is giving the logistics support, my lord, and my lord, in building the barracks and all this, my lord.
Since when you are behind the bars?
I am behind the bar, my lord, forwarding, my lord, 12/5/25, my lord.
He is helping the organization, my lord, cadres in, my lord, logistics support and supply of materials, etc. My lord. He is working for them.
Where is the order of?
He started item number. Haridas.
Okay, you are allowed to go on bail I'll dictate order in chamber after going through the earlier order.
Earlier,
I am objected, deeply objected.
Item
Yes.
44.
The chamber of dictation.
Yes, Lordship, CD has already been filed. Only Lordship needs to respondent number 2 may go, Lordship. That part, Lordship, order may be.
Oxo is there.
Yes, Fox is there. Taken a step.
Oh. Okay. Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. K. Parashar. It appears from record that this case was listed earlier on 30/7/2025 and case diary was called for and next date is fixed on 18/8/2024. However, 25. However, it appears that no notice, no direction was made for issuance of notice on the respondent number 2. Issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner has, learned counsel for the petitioner has submitted that the petitioner has already taken note steps for issuance of notice on
1/8/2020.
1/8/2025. If registry to verify, if the notices are found, same shall be processed and no fresh notice required, no fresh steps required to be are required to be taken by the petitioner. List as earlier on 18/8/2023.
Bail hearing, item 17. Item 17.
If 482 BNS application, Your Lordship. Lordship, there are 3 petitioners, Your Lordship. On the.
17 charge sheet has been laid. You are on interim. Heard Ms. G. Bora, learned counsel for the petitioners, who submits that the petitioners were granted interim bail by this court on which date?
6/12/24.
On 6/12/2024. You have appeared. And in pursuant to the directions of this court, the petitioners have appeared before the investigating officer and have cooperated in the investigation. On the other hand, learned additional public prosecutor submits that though the case diary was called for, however, in the meanwhile, charge sheet has already been laid, bearing charge sheet number
42/2024, dated 31/12/24.
Stop. In view of the fact that charge sheet has already been submitted in this case, as well as the fact that the petitioners have cooperated in the investigation, the interim bail granted to the petitioners by order dated 6/12/2024 by this court is hereby made absolute. This anticipatory bail application is accordingly disposed of.
Item 18.
Anticipatory bail application, my lord, I was granted interim protection. Thereafter, I appeared before the Iona when the matter last came up, a couple of days back, my lord. My statement was not there, my lord. But I had appeared on 2 occasions, my lord. So if you're not.
You were granted bail.
Interim protection, my lord.
No, by the IO, whether bail bond,
Yes, my lord.
whether he arrested you.
No, my lord. I appeared before the IR on 2 occasions. I was not formally arrested.
They have appeared.
So,
They have appeared, Lordship. The allegation is, Lordship, collection of illegal parking fee from the vehicles that are around Anapara area. So several persons are involved, Lordship. Some have been arrested and some have appeared before the IO after getting interim.
okay. Heard Mr. S. Nawaz, learned counsel for the petitioner, who submits that the petitioner, how many petitioner? The petitioner, namely Ainul Hussain, was granted interim bail by this court on 25/4/2025, and in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Learned additional public prosecutor, on the other hand, has produced the case diary of Bashishta PS case number 174/2025 and has submitted that the petitioner has appeared before the investigating officer, and his statement were also recorded, and his statement under section 180 BNS has also been recorded. So in view of the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to him by this court on 25/4/2025 is hereby made absolute, and this anticipatory bail application is accordingly disposed of.
Item 20.
Here is bail, my lord. FIR start from my lord, page number 1414, my lord. So regarding my lord, minority scholarship, my lord. Petitioners, my lord, they were
FIR is
third page 141. Long FIR.
what is the
Long as I looked it, but the relevant portion is, Lordship permits me, I can just point out. Lordship.
yes.
Lordship will find the complaint in a nutshell. It is the Lordship main allegation, Lordship. The complaint in a nutshell is that he so and so by his letter dated so and so informed the government of Assam that the ministry has recently conducted a monitoring and impact evaluation study and physical verification of institutions through National Council of so and so. The study report of the ministry revealed the existence of fake beneficiaries and of non-operational school institutes. It is also averred in the DO letter that the ministry has also deputed teams for field verification, wherein they found some irregularities in this regard. The DO letter, also accompanied by the field verification report of the ministry, reportedly highlighting all the irregularities and fake beneficiaries in respect of the 18 numbers of schools in Udalguri, Nagaon, and Nalbari. So this is the gist of the allegation, Lordship. Now, Lordship, if they place their case, Lordship, then I will come to the material for instance.
Yes. What is your case?
Before your lordship, my lord,
Who are you?
my lord, number 1, my lord. Dated in Federal of 7. All of them
Petitioner number 1 is?
my lord,
Who is he?
Barpeta district, my lord. Barpeta district, my lord, but in the FIR, my lord, the address is given different, my lord. Please.
You are named in the FIR. Okay.
My lord. Page 19, my lord, boldly written, my lord, regarding petitioner number 2, my lord. My lord, that it is established
Pardon
that one so and so
Yes,
And so, my lord, Ghali Rahman, resident of village Amlaiguri, so and so Udalpuri district. So and so committed forgery in the name of Netaji High English School and forging the signature of the principal. And the culprits uploaded applications in the name of same with beneficiaries on NSP portal and thereby cheated the government. Now, this is the allegation in my lord, this is regarding petition number 2, my lord. He is from Barpeta, my lord. The address is different. Apart from this, my lord, this petition number 2, my lord, he studied up to primary level, my lord. LP school pass out, my lord. Now, allegation, my lord. The allegation is that, my lord, he has uploaded application in the name of beneficiaries on NSP portal, my lord. And
in which page the allegations are made?
page 19, my lord. This is regarding petition number 2, my lord.
Page 19, which para?
Boldly written, my lord, this third one, my lord. Thus, it is established that one person, namely Shaniudul Mia, care of Ghali Rahman, resident of village Amlaiguri, Post Office Abhayapuri district, Udalguri, along with other so and so, allegedly committed forgery in the name of Netaji English School and forging the signature of the principal. The culprits uploaded applications in
Yes,
the name
yes.
of so and so. And then, like regarding my lord, is petition number. Petition number 3, my lord, page 20, my lord. Similar sorts of allegation, my lord. Page 20, my lord, boldly written, my lord. Thus, it is established that one person, namely Mofizuddin so and so, Bangaguri so and so, district Udalguri, my lord. And these petitioners hail from Barpeta district, my lord. Apart from this, my lord, 35 notice was issued to them, my lord, to appear before the IO, my lord. But they choose to appear before this court, my lord.
Oh,
And this is the notice, my lord, whereby we are asked to appear before the IO, my lord.
where is that notice?
Lordship
On which date?
was issued on, my lord, 28/5/25.
When you were directed to appear?
That was directed to appear on 2/6, my second.
What is your submission that regarding the allegations made against you?
Allegation, my lord. Considering the background of the petitioner number 2, my lord. 2, my lord, he is just studied up to LP school level, my lord. The allegation, he has forged the signature and he has uploaded in the NSP portal, my lord. And apart from this, the address of the 3 petitioners, my lord. As mentioned in the FIR, they are hailed from Udalpuri district, my lord. And these petitioners are from Barpeta district, my lord. And they are, in fact, no way connected, my lord. Even, my lord, in the FIR, if the principal of the school, signature of the principal was forged by this petitioner, my lord, he could have come forward, my lord, that these people have.
Okay. Yes, Mr. Sir.
Here, Lordship, as I have heard, Lordship, there has to be no apprehension, Lordship, because if they are different person than the ones named in the FIR, so there is no question of granting impeachment.
Yes.
And they have not also shown any relation to the incident, Lordship. For anticipatory bail, Lordship, some apprehension has to be there. So either they are the same person or either they are not the same
Except that their name tallies
Yes, Lord.
and they received notice under section.
So, Lordship, the first argument that they are not the same person that goes out of the window. Secondly, Lordship, regarding the notice which I have stated, it was first given to on Lordship. As they have already pointed out, it was given on Lordship, on the month of May. if I'm not wrong.
Yes.
Thereafter, Lordship, they, Lordship, were again served one more 35(3) notice that is on 5/6/25. On 5/6/25, they were again served second notice for them to appear on 12/6/25. They also did not comply with that figure also. So it is the submission regarding 35(3) notice. Now, Lordship, coming to the facts of the case, Lordship has already seen the FIR. I would like just to point out, Lordship, the relevant factors, Lordship. By the name of petitioner, I will come one by one, Lordship.
No, if you have issued notice to them,
But they have not complied with it, Lordship.
that means you initially don't intend to
Yes.
arrest
Yes,
if
but-
they cooperate.
But now, Lordship, as per the investigation that has progressed, now custodial intervention is necessary. And as per the note of the IO also, they have stated the same. Why I am stating, Lordship, if Lordship kindly goes to the argument, then Lordship will kindly see. Lordship, with regard to the first petitioner, second petitioner, Sanidul Mia. Sanidul Mia is petitioner number 2. Here, Lordship, the school in question is Netaji English School. That is also apparent from the FIR, but I am just pointing out, Lordship.
Yes.
Here, Lordship, the beneficiary are supposed to be the class 9 and 10 students of minority committee. And
Yes.
Lordship, the assessment year in question is 2020 to 2023. That is in respect of every school. Now, what has happened, Lordship? The actual principal of Netaji English School is Indra Prasad Boro. And
Yes.
when he was examined, Lordship, he has clearly denied submission of any application for pre-matric scholarship for the assessment year 2020 to 23. And interestingly, Lordship, this school, Netaji English School, it only has up to class 5.
Okay.
So, Lordship, the question of beneficiaries of class 9 and 10 does not arise. That is apparent from the investigation done so far.
No, why the petitioner number 2 was
Yes. Yes,
implicated?
yes, I'm coming to that. Now, Lordship, what has happened for Lordship beneficiary, the list has to be uploaded by one INO, nodal official, Lordship. It's called INO, Lordship. It is mentioned in the FIR also. And he has to upload the list along with the declaration by a principal, Lordship, of the concerned school.
Okay.
Now, Lordship, what happened in respect of Netaji English School, the principal was shown as Rupam Das. One person by the name of Rupam Das was shown as principal, and Sanidul Mia, Lordship, he was shown as INO, Institute Nodal Officer. And Lordship, the number of minority students studying in pre-matriculation phase was shown as 198 students. So apparently, Lordship is involved. And his
But
custody.
who uploaded?
Yeah, Lordship, that is also needs to be investigated. The INO is responsible for uploading it in the portal. It is the responsibility of the INO, and the INO has to be appointed by the principal, by the
No,
institute.
yes, in this case, I
In
know.
this case, Lordship, the principal is shown as Rupam Das. Who is the Lordship? Nobody knows. And this present petitioner signed as INO, Lordship. What is his authority, Lordship? Actual principal is before your Lordship, that is Indra Prasad Guru. And Lordship, it is, the school has only class 5. How come, Lordship, 198 minority students of class 9 and 10 have been shown, Lordship? So apparently, Lordship, this is a fraud. It is coming to the petitioner number 2. Now, Lordship, shall I proceed to the next petitioner, Lordship?
No, where it has to be uploaded in
the portal, Lordship.
NSP portal.
It is before
Ah.
in the FIR, if Lordship come.
No, how you came to know that this person uploaded the,
Yes, that was done by the inquiry, Lordship, which is apparent from the FIR. If Lordship kindly comes to the FIR at page 14, Lordship will see the Secretary Minister of Minority Affairs, Lordship, by letter dated so and so, informed the government of Assam that the ministry has recently conducted a research, Lordship, study. The study report of the ministry revealed the existence of fake beneficiaries and of non-operational school institute. So that was done, and also field verification was done subsequently. It is also awarded in the DO letter that the ministry also deputed teams for field verification, wherein they found some irregularities in this regard. The DO letter also accompanied by the field verification report of the ministry, reportedly highlighting all the irregularities and fake beneficiary in respect of 18 numbers of schools. Now, Lordship will kindly turn the page and Lordship will kindly come to the Netaji English School at serial number 4. Lordship will find fifth page of that file. Netaji English School. Lordship is found.
No, my query was different.
Yes.
Suppose somebody else gave the name of present petitioner.
Lordship.
There must be something in the case diary to indicate that the petitioner uploaded the said data in NSP portal. So how the investigating officer came to know that his name has been used, but that he uploaded it.
That regard, Lordship, then Lordship will take it after some time and just go through with that point.
Because unless something is there to show
Yes.
that
I understand.
who uploaded,
Yes.
otherwise anybody's name may be. You answer my query. And if it is not there, then they are entitled to get, we'll direct them to appear before. And if there is something to indicate, then we may consider your submission. Let him find out after lunch.
Item 21.
Now kindly fix the matter at 2 o'clock as my senior is engaged in another matter.
Not at 2 o'clock, after lunch. We'll
Okay, Lord.
Item 22.
Meet with your lordship.
I am on interim, your lordship. I have duly appeared before the investigating on agency, your lordship, as per the direction of this honorable court.
This is Lordship a dispute regarding a shop and its financial angle. So Lordship, he has appeared, Lordship. He appears to be a dispute over a shop, Lordship, between the two parties.
But he has cooperated.
Yes, 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 yes.
Heard Mr. T. Devry, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner Joydev Nath was granted interim bail by this court on 13/6/2025, and in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Learned additional public prosecutor has produced the case diary of this for PS case number 487/2025 and has endorsed the submissions made by learned counsel for the petitioner regarding cooperation rendered by the petitioner in the investigation. Stop. Considering the fact the petitioner has complied with the directions of this court and has cooperated in the investigation. The interim bail granted to him on 13/6/2025 by this court is hereby made absolute. Send back the case diary. This bail application is accordingly disposed.
I'm very grateful.
Item 23.
May I please, Lordship? My lord, may kindly see FIR page 12. One person, my lord, namely Mazaharul Islam, was caught red-handed by police with some fake documents like
Aadhaar card, PAN card, etc. And also seized his mobile. And this person is my immediate neighbor, man. This person.
Who are you? What is your name?
I am Muhibullah.
Mohibullah.
Now, he implicated me that I have helped him in making those fake documents. But thing is this, since long, there is a family dispute and land dispute between the two parties. Lordship would see everything has been recovered from Mazharul Islam. Mobile number also, kindly see, he was arrested and ultimately he was granted bail. Here that he was forwarded, that is page 15. And kindly see the seizure list, my lord. Seizure list, your lordship would see, from the seizure list, your lordship would see that everything was recovered. Here,
How you came to know that he implicated you?
no, he implicated me because I was not there. He
No,
brought the
how
police.
you came to know?
I was not there. He brought the police to my house, and police, when my name was told, I ran away due to the reasons that he may implicate me. But nothing is recovered. The case is of 2023, my lord. Case is of 2002 years late, earlier. But thereafter, police did not charge me. But now, a pulsar bike at the instigation of Mazharul Islam has been taken by police, and that pulsar bike belongs to me. That is not given. You giving first the bail order, then only the car would be, pulsar bike would be handed over to you. Now, Lordship would say everything was recovered from the possession of this Mazharul Islam, my lord. Not from me. Nothing was recovered from me. So, your lordship would see that Mazharul Islam is the only person from whom some persons in page 13 may kindly be seen. One GME 5G mobile phone, one Apple phone these are the recovered from this Mazharul Islam. And in addition
And
to this,
whose
my lord,
motorcycle was seized? How your motorcycle was seized?
when I saw police and he is coming, we have family dispute since long. So I went away and there was my motorcycle that was taken by police. But since last 2 years, 23 case, police is not charging me. But I went, I sent my person. Police said that if he gets bail, then we will release the motorcycle. So now I am mainly for motorcycle, that unless I get bail, motorcycle is there, it is already damaged. Even
Yes.
then now.
You came very late.
So, my lord, on the basis of the statement of co-accused, I have been made accused, but nothing is found.
Yes, Mr. Parash.
Malat, everything is from Mazharul Islam. Because he fled away, Malat, how can seize from his position, Malat? Mazharul has a shop, phone repairing shop, Malat. And he used to give Malat connection of SIM card connection, he provided Malat, Airtel and all this, Malat. So people give their Aadhaar card and all this to get SIM cards. Now this person, this petitioner helped Malat editing those Aadhaar card, inserted the photograph of Mazharul and print the document Aadhaar card. They put in the name of one Ajay Gupta, in his PAN card, his Aadhaar card, Malat, took the loan from three companies, L&T Finance Company, BMI Finance Company and Trillion Finance Company, total 10 lakh.
Who took loan?
Loan in the name of Mazharul Islam. But regarding preparation of those documents, Ajay Gupta gave those documents only to get the SIM card, PAN card and Aadhaar card. Now this person, Malat, put the photograph of Mazharul and print those documents as e-Aadhaar and all this, and make the fake document, and on the basis of that fake document, now fact is that yes, from 3 company malad, IDFC Bank malad 10 lakh rupees,
No, no.
they took loan.
How
Now,
you came to know that he prepared the fake documents?
his preparation, that is from the statement of the
Mazharul.
Mazharul.
Mazharul has implicated him.
Yes, he is a malad asset person. malad.
And
Now-
my,
But
now-
for last, yes, yes.
Now fact is that, yes. 10 lakh rupees loan has been taken, my lord, in the name of that person, my lord. And in that process, some bank official may be also related. Without the connivance of the bank official, my lord, if verification is clearly done, no one can took loan in showing the photograph of other persons, my lord.
Yes.
So to honor that record also, my lord, his custodial intervention necessary.
But for last 2 years, you have not arrested him.
Yes, well, he's untraceable, Malat, at that point of time. Now he's seeking anticipatory bail, Malat.
Let him appear,
Malat, these,
Yes, I will
in
appear.
these cases, Malat, it is difficult, Malat.
but you give me the case diary.
I'll
Except Mazharul's statement,
I'll flag mark, Malat.
your submission is that except Mazharul's statement, there is nothing now.
Yes, Caesar list is, Malat, from the Mazharul, but from the, at this point of time, when investigation is still going on, Malat,
will anybody
We have
allow
to-
that I will make fake documents for getting loan by another person?
Okay, let me see the case
for
diary.
what purpose? It may be Mazharul may took loan, but for what purpose? He made the fake document. He may not know.
We'll continue with this at 2. At 2. In the meanwhile, give me the case diary. I will verify. At 2, I will dictate the orders. I could not go through the case diary. I'll go through the case diary and pass orders.
Well.
You have any, I have already heard you.
At some points, my lord, if your lordship permits me, some points lordship would see, page 12, kindly see for a moment.
Yes. Page
Page 12. Second para, last portion. One person, namely Mazharul Islam, son of so-and-so, village so-and-so, Moirabad in connection with the above matter, in the sting operation, we have seized the below listed items. So all these items have been recovered from Mazharul. Thereafter, lordship may kindly see page 14. Page 14. In middle portion, after that we proceeded to house of Mufidur Jaman, and found many suspicious documents relating to these kinds of activities as seized as mentioned below. So Mufidur Jaman, nowhere lordship would see that anything was recovered by possession. Then, my lord, altogether, everything has been recovered from the possession of Mazharul or Mufidur, and there were 5 numbers of accused arrested by police. Kindly see page 18. Page 18, Mazharul, Asadul, Umar, Sadiq, Jahangir, Wasim Akram. My information is this, my lord. All these persons have been released on bail. And we have annexed the bail order of Mazharul Islam. Here, lordship may kindly see page 20. Only few days later, he has been granted bail. Few days later. This Mazharul Islam, the prime accused, he has been granted bail by our High Court. That operative portion of the order, release order, bail order, may be seen at page 22, para 9. I have scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the present petitioner. That means Mazharul Islam. Investigation has been also progressed to a considerable extent. The petitioner has pleased to cooperate with the remaining part of the investigation as well as with the trial. It appears that further detention for the progress of investigation may not be required. So, my lord, this order was passed on 4/1/24. So at that time, investigation was in progress. And today we are 5/8/25. So, my lord, sufficient time police has got. And my only thing is this, my Pulsar bike has been taken. Otherwise, I did not move the bail petition. So it is now for the Pulsar bike, I have to go. Now, my lord, someone if seeks my help, I may help, but whether I have help in making fake documents or not, this lordship has perished the case diary. So my submission is this here, against Mazharul also, the Honorable Court has said that there are incriminating materials, but as the investigation has been progressed a considerable extent, so he has been granted bail on 4/1/24. So, my lord, in that view, my lord, I will fully cooperate. At any condition, I may.
Heard Mr. M.U. Mahmood, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of DNSS has been filed by the petitioner, namely Mahibullah alias Mohibullah, who is apprehending his arrest in connection with Moirabari PS case number 224/2023 under section 120/421/467/471/406/34 of the Indian Penal Code, read with section 66C/66D of the Information Technology Act. The gist of accusation in this case is that on 2nd November 2023, Pankaj Das had lodged an FIR before the officer in charge of Moirabari Police Station, inter alia, alleging that an email has been received from one Ajay Gupta regarding suspicious bank transactions in IDFC Bank using his credentials in the state of Assam. It is also stated in the FIR that during preliminary inquiry made in this regard, it was found that one person named Mazharul Islam was involved in the offense alleged therein, and accordingly he was apprehended and suspicious materials like Aadhaar cards, PAN card and voter ID card were seized therefrom. It is also alleged in the affair that the said Mazharul Islam implicated the present petitioner during interrogation and some other co-accused persons. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offence alleged in the affair. He further submits that the petitioner is immediate neighbor of the co-accused Mazharul Islam, and there has been family dispute between them, and therefore he has been falsely implicated in this case. Stop. He also submits that nothing was seized from the possession of the present petitioner except one Pulsar bike He also submits that incriminating materials were seized from the FIR named accused persons, namely Mazharul Islam and one Mofidul Zaman. He also submits that in the meanwhile, the investigating officer has arrested 5 accused persons, including Mazharul Islam, in connection with the case. He further submits that all the 5 persons have already been granted bail by the bail. He also submits that said Mazharul Islam by granted bail by a coordinate bench of this court on 4/1/2024, and while granting bail, an observation was made that the incriminating materials are there only against said Mazharul Islam. The petitioner submits that this is an old case of almost 2 years. Of almost old case of the year 2023, and the petitioner is ready to cooperate in the investigation. He submits that by now investigation might have progressed, and as the petitioner is ready to cooperate in the investigation, his custodial interrogation may not be necessary. On the other hand, learned additional public prosecutor Mr. K.K. Parashar has objected to grant of anticipatory bail to the petitioner and has produced the case diary of Moirabari PS case number 224/2023. He submits that the petitioner is the accomplice of the FIR name accused Mazhar Islam in commission of the alleged offense. He submits that there are materials in the case diary against the present petitioner in having participated in the forging of documents on the basis of which Mazharul Islam took 3 numbers of loans from different banks. Stop. He submits that since of
Total 10 lakh.
total 10 lakh rupees. He also submits that since this the offense involved in this case affect the economy of the state, lenient view should not be taken, and anticipatory bail may not be granted to him. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. I have not gone through. I will go through and pass the remaining part. I will go through the case diary and dictate remaining part in chamber.
One thing, my lord, I have the information that all the accused, arrested accused person have been given information. That is from the party, not by personal knowledge. That way can be
That is your
dictated.
submission.
Yes, I have.
Case in line. No. Eta line लिख रखो. Learned counsel for the petitioner has submitted that he has been informed
Yes.
that in the meanwhile, all the arrested accused persons have been released on bail. I will go through the case diary and then pass it.
All right.
Item 45.
Make legal. Lordship order dated 30th July. Kindly be given.
Yes, notice was not sent.
Lordship.
We'll send notice now.
We have already taken a step on the 31st July.
Give me an item number.
45.
Oh, that's it.
45.
Heard Mr. R. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. On perusal of the order dated 30/7/2025, it appears that though the case diary was called for in connection with this case, however, no notice to respondent number 2 was issued. Learned counsel for the petitioner has submitted that in spite of that, the petitioner has already taken steps for issuance of notice on
31st July.
31st July 2025. Hence, he prays that the notice may be issued. Stop. Let notice be issued to respondent number 2. As the petitioner has already taken steps for issuance of notice, no fresh steps is required to be taken. Registry to process the steps, registry to issue the registry to process the notices in person to the prevailing notification of the registry in this regard. Let the case be listed again on 18th of August.
Item 20.
Yes.
On a query, Lordship, regarding the involvement of the petitioner with regard to uploading. Lordship. So, Lordship, if I may just point out the procedure, Lordship, then only it will be clear. What has happened, Lordship, they have projected themselves as INO, Lordship, and in that, in an INO, they have to get the documents verified by the principal of the school. Apparently, Lordship, the fake principal has been shown. And Lordship, the documents that has been uploaded, it comes with their photograph, and Lordship, they have to upload their Aadhaar card. Why Aadhaar card, Lordship? Because the Aadhaar card carries the phone number upon which the OTP is sent by the nodal agency for each student. Lordship. suppose, Lordship, I am uploading 100 students' name. I know I will upload 140 students' name in the uploading, Lordship. There, Lordship, in my Aadhaar card phone number, the phone number which is registered in my Aadhaar card, there, Lordship, 140 OTPs will come. That phone number belongs to the present petition.
Okay,
apart-
that's how you locate it.
Yes, that apart, Lordship, the Aadhaar card that has been uploaded is of the present petitioner. The Aadhaar number is okay, but the page, the web page, Lordship, where the address is given, that has been manipulated to show an address of Udalguri. Now, Lordship, what has happened when the OTPs were sent, Lordship, the OTPs are in hundreds, Lordship. Those OTPs came into their mobile numbers. The investigating agency, Lordship, collected the CAF, Lordship, customer application form of their mobile number, and their, Lordship, their details have come up, Lordship. And from there, their actual address has been taken, and thereafter they have been searched.
Okay,
So that is.
so there are materials.
There are materials. Now, Lordship, I have submitted in respect of Sanidul Mia already. If Lordship wants me, I can submit once more, Lordship.
Yes,
Shall I?
yes, yes.
Regarding Sanidul Mia, Lordship will find he belongs to Netaji English School, Lordship. The school in question is Netaji English School. There, Lordship, the actual principal name is Indra Prasad Boro, the actual principal. And the school offers education up to class 5. That I have already pointed out, Lordship. And question of class 9 and 10, Lordship, beneficiary student does not arise. And what they have done, Lordship, Sanidul Mia has projected himself as institute nodal officer and shown one Rupam Das as principal who has signed those documents with fake seal, signature, everything. And Lordship, the number of beneficiary that has been shown is 190.
Okay,
Now, in respect of Lordship, the accused Mofizuddin, that is the petitioner number P. He is associated with Lordship Hajong Basti High School.
okay,
Hajong Basti High School, there the actual principal is Rotoni Das. From her declaration, Lordship, the number of students studying in class 9 and 10 belonging to minority committee is 20 and 45. Class 9 is 20, class 10 is 45. But Lordship, she has stated that she has never appointed any INO, nor any student has applied for scholarship. That is the statement of the actual principal, Lordship.
okay.
And Lordship, here the fake principal has been shown as Tinku Sarkar. And 202 students were shown as beneficiary, Lordship. Now, Lordship,
Okay, you need their custodial
yes,
interview,
absolutely.
but initially you should,
Initially, they did not comply. It was at a very initial phase, Lordship. Now, when those materials have come up, Lordship, it becomes all the more imperative.
heard, Mr. What is the name?
Jealous. Well, only one
Yeah.
thing, my lord. I have, my lord, considering the background of the petitioners, my lord.
Jailhouse.
Lord.
No, that you have submitted.
Now, my lord, one is a delivery boy, my lord, of a food, my lord, Swiggy food, my lord. One is a the grill shopkeeper, my lord, and another is my lord. My lord, they are considering their, my lord, educational background, my lord. How this person having such limited qualification can upload all these things? Someone may have, my lord, misuse their ID, other cards, my lord. So, my lord, they are ready to cooperate with the investigation. The subsequent 35 notice they have not received, my lord. They are giving undertaking, my lord, they will.
Heard Mr. Jailhouse Scott, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners namely Mokibul Islam Bhuya, number 2 Sanidul Mia, number 3 Mofizuddin, who are apprehending their arrest in connection with CIDPS case number 1/2025 under section 120B/420/468/471 of the Indian Penal Code, read with section 66D of the Information Technology Act. The gist of accusation in this case is that on 4/1/2025, one Nirmal Biswas, Deputy Superintendent of Police, had lodged an FIR before the officer in charge of CID police station, inter alia, alleging that on the basis of an inquiry conducted on receipt of a complaint regarding irregularities in certain irregularities and existence of fake beneficiaries in respect of 18 numbers of schools of Udalguri, 18 numbers of schools in the district of Udalguri, Nagaon and Nalbari. Stop. It is also alleged in the FIR that the petitioners had impersonated themselves as institutional nodal officers and have uploaded forged documents in the NSP portal so as to get this is for getting scholarships or getting the funds earmarked for giving scholarship to the students of minority community. A Planet Council for the petitioner has submitted that the petitioners are in no way involved in the offense alleged in the FIR. He submits that the schools in question are from Udalguri districts. However, the petitioners are the resident of Nalbari, Borpeta district. He also submits that the petitioner number one is
My lord, question number 1 is having a cloth shop, my lord. Studied up to class 8, my lord.
has studied up to class 8 and is a shopkeeper. Petitioner number 2 is
He is having a grill shop, my lord, studied up to primary school, my lord.
has studied up to primary school and does business of preparing grills. And petitioner number 3 is
A delivery boy, my lord.
a delivery boy at Swiggy.
What?
He therefore submits that they don't have the technical expertise of uploading the required information at the NSP portal as alleged in the FIR. learned counsel for the petitioner also submits that the petitioner received notice under section 35(3) of BNSS, which itself indicates that their arrest is not necessary for the investigation of this case. He further submits that as the non-bailable offences are involved in this case, the petitioners apprehended that if they appear before the investigating officer, they may be arrested, and therefore they approach this court seeking bail. It is further submitted that the petitioners are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has vehemently opposed the grant of anticipatory bail to the petitioners at this stage. He submits that at the initial stage of investigation, the investigating officer issued notices under section 35(3) of BNSS on 2 occasions to the petitioners. He further submits that in spite of receipt of notices, the petitioner did not appear before the investigating officers. He also submits that when the notices were issued, the investigation was at very initial stage. Now, investigation has progressed and incriminating materials have cropped in. He submits that the petitioners impersonated themselves as institutional nodal officers and have uploaded fake documents of the fake students for getting the benefit of scholarship, getting the funds earmarked for the scholarship of minority students. He also submits that even the signatures of the headmasters of the schools for which fake documents were uploaded in the NSP portal were forged by the petitioners. He also submits that the phone numbers of the petitioners helped the investigating officer to trace out the involvement of petitioners in the offense alleged in this case. And at this stage, their custodial interrogation is required for the fair investigation of the case. Hence, he has opposed the grant of anticipatory bail to the petitioners. I have considered the submissions made by learned counsel for both sides and have gone through the case diary produced by learned additional public prosecutor. It appears that though at the initial stage, notice under section 35(3) were issued to the petitioners on more than one occasions. However, they failed to appear before the investigating officer. It also appears from the case diary that the present petitioners There are materials in the case diary to indicate that the present petitioners uploaded fake documents in the NSP portal by impersonating as themselves as institutional nodal officer for the school. And they have also forged the signatures of the principals / headmasters of the said school. So considering the incriminating materials available in the case diary against the above named petitioners, as well as considering the nature of offense involved in this case, this court is reluctant to grant bail, anticipatory bail to the petitioner at this stage. The prayer for bail, prayer for grant of anticipatory bail to the above named petitioner is therefore rejected.
Item 21. May I please, after obtaining the pre-arrest bail, I have duly cooperated the investigation. I have appeared and submitted all the relevant documents as well as
Yes, Mr. Parashar.
the mobile.
Yes, he has appeared, statement also recorded, but one thing is that I'd like to point out, one main culprit here is one Anupam Bharali. He, this matter is regarding from small finance bank, some current account has been used for online gaming. And this petitioner, he in his statement also he has stated that he has given his account and it was used by that Anupam Bharali, where money from different source money has come. And he on several occasions he used his Swift card, this petitioner Swift card, to which was used by Anupam Bharali, and he along with Anupam, he took Anupam Bharali to different place to convince some people. In all along with Anupam Bharali, he was there. He used to drive a car, Swift car, his vehicle used, and all the places he go.
So his involvement is there.
He give his bank account of
vehicle was
small finance bank, and because that is a current account, and that account was used by Anupam Bharali, where money has come from different source and regarding this online gaming. So Anupam Bharali is the mastermind. Online gaming is given. So he needs some account, those current account, and current account of this petitioner he has used this current account.
I am doing business, that's it. And on that
Now, do you need his?
Yes, I am reading only one. Here do কেইজনমান মানুহে লগ পাই যদিও আমি হোটেলত থাকোতে পুলিচ আহে আৰু পুলিচে বিচাৰত মই হোটেলৰ পৰা পলাই আহোঁ. So he played out. Other persons arrested, and his account, current account has been used. মই সিহঁতৰ লগত বহুত ঠাইত যাওঁ, মই গাড়ীৰ ভাড়া লওঁ যদিও কেতিয়াবা কাৰেণ্ট একাউণ্টত থকা মানুহে চিনাকি কৰি দিয়ে, নাইবা মোৰ ডিটেইলছ লৈ অনলাইন গেমিঙক লগাব পাৰিলে কমিশ্যন পাওঁ. So he got the commission, because his account has been used in that online game.
No. Assuming that there are materials,
Okay.
he is cooperating. Do you require his custodial integrity?
Yes, after getting the interim bail, he has appeared in statement recorded, but there are
Materials against you?
materials against
I
him.
may be allowed to submit.
No. Then file charge sheet against him. Heard Mr. P.K. Sharma, learned counsel for the petitioner. Also, Mr. D.P. Goswami, learned additional public Also Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court on 10/6/2025. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Vishwanath PS case number 105/2025 and has submitted that though the petitioner has appeared before the investigating officer in pursuant to the direction of this court, and his statement has also been recorded. However, during investigation, it was found that there are sufficient materials against him in the case diary. You are opposing?
It's a category A offense as per the
Yeah.
until judgment. So discussion in favor of the accused.
He also opposed the making of the interim bail absolute on the ground that custodial interrogation of the petitioner would be necessary. I have considered the submissions made by learned counsel for petitioner, learned counsel for both sides, and have gone through the case diary of Vishwanath PS case number 105/2025. Though there appears to be some materials against the petitioner in the case diary, however, it also appears that the petitioner has complied with the directions of this court and has cooperated in the investigation. It is not made clear as to when the petitioner is cooperating in the investigation, why his custodial interrogation is necessary in this case. Stop. This court is of opinion that if he continues to cooperate in the investigation, the custodial interrogation of the petitioner may not be necessary for fair completion of the investigation of the aforesaid case. For aforesaid reasons, the interim bail granted to the above named petitioner on 10/6/2025 is hereby made absolute, subject to the conditions absolute with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary. This anticipatory bail application is accordingly disposed of.
I'm deeply obliged. In 25.
This is a 3 years jail application already in terms of the interim bail granted by this by this honorable court. I have duly appeared and recorded my statement. And also, Lordship, similarly,
available.
It was bulky case diary.
Yes,
On-
but I have to save time, I have flagged my lordship, and I have noted down the relevant page number also.
What is your submission? He has, no, you keep it with yourself. If required, I will call.
Lordship, here in this case, sufficient material has been gathered by the investigating agency lordship. And lordship, this candidate was not the deserve to get this post lordship. She has deprived 7 numbers of candidate lordship, deserving candidates by way of this procedural lordship. There is an expert committee report also. And they said the entire process of the selection was compromised, lordship. And there were, lordship, manipulation of the answer script also, used in the marks also. where
What
marks-
examination?
Lordship,
Assistant Tourist Information Officer,
Assistant?
Assistant Tourist Information
Officer.
Tourism Department. tourist information. Now they have already been promoted, Your Lordship. Petitioner is already promoted to tourist information. Working, last talking year, now the FIR has been lodged. Already similarly situated incumbent, they have been granted bail, Your Lordship.
But Lordship, another candidate petition has been rejected. Lordship,
That
after
is,
period in the case diary, and she was also granted interim Lordship, but interim was rejected.
her allegations were different, Your Lordship. In
Not
this
same
case-
Lordship, same candidate.
In
same
this
candidate.
case, similar allegation, Your Lordship, I show, interim was granted.
What is the accusation against you?
Lordship, at paragraph 9, first Your Lordship may kindly see page 19. This is the FIR, page 19. To the officer in charge, Vigilant Police Station, dated 15/5/2025. In inviting a reference to the subject cited above, I am submitting this report for the purpose of registering a criminal case under appropriate sections of the law against the public servant named herein and others pursuant to the final inquiry report by regular inquiry number 5 of 2025. The report contains substantial evidence of abuse of official position, dereliction of duty, and acts amounting to criminal misconduct under the Prevention of Corruption Act 1988 as amended in 2018 and under the Indian Penal Code. It is to be noted that a serious allegation was made by Sri Vijay Sharma regarding the illegal appointment of 8 posts in the rank of Assistant Tourist Information Officers in the Directorate of Tourism Assam during Sri Rakibul Hussein's tenure as Tourism Minister in the year 2010-11. These appointments were purportedly made under Srimati Monalisa Goswami's directorship based on ministerial recommendations. As per approval of the Honorable Chief Minister Assam by UO number such and such dated 1/2/2025, a regular inquiry was initiated by RE number 5/2025 and inquiry was endorsed to me. Your Lordship, some anonymous person has lodged a complaint and his full name is also not given, his antecedents are not given, address is also not given. How is he related to this case? Nothing is mentioned. Pursuant to that, this inquiry has been given and consequently in pursuant of the inquiry report, this FIR has been lodged, Your Lordship.
What is your name?
My name is, Lordship, at paragraph 7, I am a selected candidate at serial number 5, Mehzabin. It should have been Mehzubin, Your Lordship, Mehzabin Begum. At paragraph number 7, I am stated as one of the selected candidates, and my allegations are at paragraph number 9, Your Lordship, the relevant. During inquiry, it is found, page 21, Your Lordship. During inquiry, it is found that marks were manipulated against most of the candidates without any signature in the mark sheet of viva voce of candidates. On scrutiny of the answer scripts of written test of the qualified candidates selected for the post of Assistant Tourist Information Officer, it is found that overwriting was made with multiple colored ink while writing some answers in the answer script of written test of the selected candidate bearing roll numbers 630 of Ms. Saimin Mannan and roll number 715 of Mehzabin Begum. Lordship, now this Saimin Mannan, similar allegations, he has been granted PRS bail already by this honorable. Now, the paragraph 12, if Your Lordship comes, during inquiry on analyzing our merit list of candidates and the selected list by the Directorate of Tourism Assam, the following has been found. My name is at serial number 5, Ms. Mehzabin Begum, General. As per them, I have obtained 130.5 marks and my rank ought to have been 12 instead of 5. And Lordship, in table 2, they have given next page. They have stated that one Surojit Borua at serial number 5 ought to have been selected. And table number 3, they have given a comparison chart. This Mehzabin Begum, I have secured 130.5 and Surojit Borua, according to them, she has secured 135.25. So from the paragraph 13, the allegation is that I have deprived this Surojit Borua. That is the allegation. On the basis of only one sentence they have written in paragraph 14 that in lieu of illegal gratification, this has been done. And accordingly, in terms of paragraph 15, I have been at serial number 6 shown as an accused. Now, Lordship, already one similarly situated candidates, he has been granted bail, Your Lordship, interim protection
and I have already appeared also, and my statement has also been duly recorded. And my appointment letter, I want to place, Your Lordship, at page 27 of my petition. This is my appointment letter.
No, accusation against you
Yes, Your Lordship.
was that the answer scripts on examination,
Yes,
in your answer script, overwriting was found
yes.
with multiple color ink.
Yes. But how that overwriting has vitiated my selection?
Any other accusation?
No, Your Lordship, only this much and.
Why
Lordship.
Surajit Purva was earlier not declared to be selected?
That they have conducted a parallel marks, they have conducted a parallel evaluation, and according to them, this vigilance has conducted a parallel during the course of inquiry, a parallel evaluation they have done, and they have said that he ought to have been selected.
Parallel evaluation means?
They have separately, they have done an evaluation of the answer script that were available of my selection. Already I was duly selected.
It was OMR based.
No, perhaps subjective.
Subjective, then who evaluated?
At that time, we don't know, Your Lordship. The selection committee was there. They have selected me. I was selected. I am working. Now the allegations have, after 14 years. And in the meantime, I have already.
Or was there the calculation was not done properly?
No, that is not the allegation. Now they are saying that some overwriting, how it has vitiated my marks, because marks they have stated that I have obtained 130.5. And in the next chart 3 also, they have stated that my marks are the same, 130.5. Only in respect of Viva, they are saying there is some overwriting. Now that the selection committee will know, Your Lordship. What was done while giving marks in the Viva. It is the discretion of the selection committee. That part we don't have any control.
Yes.
And
Lordship.
She has appeared before you. You have recorded her statement.
Lordship, but yet we have sent the expert opinion, Lordship, the entire manipulated documents, Lordship, FSL report yet to come. And here, Lordship, this candidate conduct has been sufficiently proved, Lordship, by way of sufficient material, Lordship, and she has also admitted in her statement that the answers were not in her handwriting. Someone else had, but it implies that there was something done by the candidate from the actual, Lordship. Again, Lordship, her marks were increased from 27 to 50. That is availability in the case diary, Lordship. Again, there are statement of various witnesses who has implicated this petitioner, Lordship, and it has been sufficiently proved that her marks were intentionally increased to get her promoted in the merit list and selected, Lordship. Her serial number in the general merit list was serial number 12. But surprisingly, she came to number 4. Five, Lordship. Lordship may go to have a small objection prepared by the investigating agency, Lordship. Everything has been explained here.
No, you explain to me.
Yes,
Why do you need custodial interrogation now when she has appeared and you have already found out?
Because, Lordship, some more information yet to be gathered, Lordship, because its investigation has not completed yet. We are gathering the required information, collecting the documents, Lordship, and some documents have been sent for FSL also. We need her custodial retention also, Lordship, because their signatures are yet to be come, Lordship, of expert opinion. Again, Lordship, there are some more information has been come. Lordship. And it is clear, Lordship, from the investigation that her marks were added. Mezubin, Lordship, her mark, she was the candidate who got the highest mark added, Lordship. she got 34 marks added, Lordship. Again, Lordship, it has been proved that, Lordship, the answer script was not countersigned by the evaluators, Lordship. And merit is, in the merit is also, Lordship, there is no signature of the evaluators, Lordship.
No, that
Again,
is,
Lordship,
that is not my query. My query is you found these things, but why you need her custodial interrogation?
to gather some more information because
If she cooperates, if she comes to you and cooperates,
but Lordship, in a similar case, Lordship, another candidate, Lordship, that bail application has been rejected after facing this same case, Lordship. And I have already shared with that order, Lordship. Because Lordship, it's a corruption case, it's against society. Because kindly see, Lordship, what happened to
No,
the
no.
other deserving candidate.
you do the proper investigation and you find, if you find incriminating materials, file the charge sheet at the earliest.
Lordship, that are
You
doing,
don't-
that part has been going on.
Heard, Mr. GZ Ahmed. Who got, this is the rejection order. Where is the,
That is the rejection of one of the candidate, one of the petitioner in this case. Then same effect.
GZ Ahmed, learned counsel for the petitioner. Also had Mr. PJ Burman, learned additional special public you are special public prosecutor or additional?
Additional.
Learned additional special public prosecutor. This application for anticipatory bail has been filed by the petitioner May Zubin Begum, who was apprehending her arrest in connection with Vigilance PS case number 13/2025 under section 120B/406/409/420/467/468/471 of the Indian Penal Code, read with section 13 within bracket 1 within bracket small d /13 within bracket 2 /12 of the Prevention of Corruption Act 1988. The gist of accusation in this case is that on the basis of the report of final inquiry bearing regular inquiry number 5 of 2025, the Inspector of Police, Mr. Nipu Kolita, had lodged an FIR before the officer in charge of Vigilance Police Station, alleging therein that during recruitment process to the post of 8 Assistant Tourist Information Officer in the Directorate of Tourism Assam, anomalies had occurred and the persons entrusted with conduct of the recruitment process indulged in corruption. It is alleged in the FIR that the present petitioner, namely Jabin Begum, was Jabin Begum secured 12th position in the select list. However, in the final select list, he was shown at 5th position. It is also alleged in the FIR that overwriting, it was found during investigation that the answer scripts of the present petitioner bears overwriting with multiple colored ink. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by a coordinate bench of this court on 25/6/2025, and in pursuant to the directions of the court, she had appeared before the investigating officer and has cooperated in the investigation. He further submits that one of the co-accused, namely Miss Saimin Mannan, was also granted interim bail by a coordinate bench of this court. No, was granted absolute anticipatory bail by a coordinate bench of this court on 26/2025 in AB case number 1264/2025. He submits that the petitioner who has been granted bail, said accused persons who has been granted bail, stands on same footing like that of the present petitioner. Learned counsel for the petitioner submits that the petitioner is ready to abide by any condition imposed by this court while making this interim bail absolute, and therefore the requirement of custodial interrogation may not be there. Hence he prays for making the interim bail granted to the petitioner absolute. Stop. On the other hand, Mr. P.J. Burman, learned additional special public prosecutor, has produced the case diary of Vigilance PS case number 13/2025 and has opposed the grant of bail to the present petitioner. He submits that the petitioner has indulged in corruption and unfair practices to get herself selected as assistant tourist officer. He submits that sufficient incriminating materials were found during investigation which justifies and sufficient incriminating materials were found during investigation against the present petitioner. He also submits that though the statement of the petitioner has been recorded under section 180 of BNSS, however, considering the incriminating material, against the petitioner on record, her further custodial interrogation may be required, and hence he prays for cancelling the interim bail granted to the petitioner, vacating the interim bail granted to the petitioner. He also submits that one of the coordinate bench of this court has also rejected the prayer of anticipatory bail of one of the co-accused, namely Ananya Borthakur, who stand on the same footing like that of the present petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the case diary which was produced by learned special public prosecutor. It appears that there are some incriminating materials against the petitioner in the case diary. It also appears that the petitioner has complied with the directions of this court and has cooperated in the investigation. A statement under section 180 of BNS has also been recorded by the investigating officer. Under such circumstances, though the investigating officer, though the learned special public prosecutor has submitted that the custodial interrogation of the petitioner may be required. However, same could not be justified in view of the fact that the petitioner has been cooperating in the investigation. As the petitioner has complied with the directions of this court and is cooperating in the investigation, this court is of considered opinion that her custodial interrogation may not be necessary if she continues to cooperate in the investigation, for fair completion of the investigation of the aforesaid case. For the aforesaid reasons, the interim bail granted to the petitioner, granted to the aforesaid above named petitioner by order dated 25/6/2025 is hereby made absolute with a condition that the petitioner shall continue to cooperate in the investigation and shall not either directly or indirectly make any inducement, threat or promise to any of the person, any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts to the investigating officer. This anticipatory bail application is accordingly disposed of. Send back the case into return.
10:26.
Hard time. Only ground is medical ground, or let us try lift your lordship.
More the number of time More weak your case becomes.
Diary needs to be updated, my lord.
Huh?
Update.
What medical ground?
Petty liver.
Medical ground is also.
That I was asking, what is that, man? So it differs from person to person. Man.
You could not find any other.
It may be heavy for me. It may not be Mr. Mahajan. That's right. But
Let the case diary
it
be
differs from
updated.
person to person.
Let the case
It is
diary
already
be.
issued by correspondent Adjournment.
It is a POXO matter.
Oxford.
Okay. 26. No,
Private party নাম আছে না নাই? নাম আছে না?
no, none of the.
Okay, হয় না।
Notice.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. M.H. Laskar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary is available, however, same is not updated and requires updation. It also appears from office note dated 24/7/2025 that the service report in respect of notices issued to respondent number 2 has not yet been received by the registry. Stop. Learned additional public prosecutor is requested to get information regarding the fate of notice issued to
From the officer
respondent
in
number
charge.
2 from the officer in charge of jurisdictional police station, and let this court know about the same on the next day. Okay. Let also an updated case diary be called for. When? 21.
21.
Let this case be listed again on 21
Always.
July, 21 August.
City not receiving.
You are on interim. Take a short date.
Yes, Sila Pathar Malat.
Heard Mr. U. Datta, B. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed.
Malat 19.
Let this case be listed on 19th of August.
28.
CD was called for and
Is there
taken the step.
Oximeter.
Yes, madam. On 15/7/2025, I've taken the step.
CD is available only that. Malat,
CD is available.
CD service report is.
We appoint somebody.
Malat,
Heard Mr. ATM Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary is available, however, the service report in respect of notice issued to respondent number 2 has not yet been received. Stop. As the case diary is available, this court intends to appoint one amicus curiae to defend the cause of respondent number 2 in this bail application. Accordingly, Shri N. Mahajan, whose name appears in the list of amicus curiae, is hereby appointed as amicus curiae for respondent number 2. The petitioner is directed to furnish a copy of bail application along with annexures to the newly appointed amicus curiae The registry is directed to reflect the name of Mr. N. Mahajan as amicus curiae for respondent number 2 in the cause list henceforth. List this matter on 19/8. You may give shorter date,
Short time, date will be given,
13/8.
13.
13/8. Let the case diary be retained till next date.
Item 29. City noticing. Commercial quantity.
Lordship, the CD was called for on 19th July. There
Yes,
has
sir.
been significant time.
What is your submission?
Your Lordship,
What can I do?
Your Lordship, if your Lordship goes to the FIR on page 11, your Lordship.
Can we
will see that-
consider,
Commercial quantity in.
consider
But
now?
not recovered from my possession, from the car that was outside. And then police said that they have identified someone at a later stage. And
Therefore, case diary.
This presumption has been drawn because there is already a case going on against me, which they have mentioned in the FIR. So I'm trying to be made a scapegoat here because I have been previously associated with it. And I have been participating in the previous trial as well, and that has not been hampered due to my absence. So if I'm allowed to go on interim, I will participate in the present investigation as well.
No, interim
Today is
or
second
getting
day only
interim,
after
you have to jump 37. To jump 37, we need to peruse the case diary. Heard, Mr. What is your name?
A. Mishra.
A. Mishra, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter.
19.
9
Be short, Your Lordship. Already 17 days, your Lordship, and not even once the diary. has-
short,
15 of, not before 15.
19. 15th August is there. It may not come. So 19.
30.
Much appreciated.
Item
Post
number
30 may be taken up, Lordship. Here, Lordship.
30.
Here, Lordship. I have detailed the reason of my apprehension, Lordship. The reason of my apprehension, I have categorically stated that para 3 of my petition. And in this matter, Lordship has already dealt and in a similar situated standing Lordship. Lordship has also given the privilege of PRS bail to other person, Lordship.
Co-accused. Same case.
Lordship. And here,
Where is the order?
Lordship.
Wow.
Some has granted, few has rejected also.
Few has
Matlab,
rejected
AB,
also.
BA rejected and few AB. Matlab, that matter is regarding fake matlab certificate and of matlab.
Lordship, let me, Lordship, my case
Oh,
is that,
yes.
Lordship. Here, my case is that, Lordship. Now I have come across with a notice for appearing before the concerned police station, Lordship. Now, I have detailed the reason of my apprehension, why I can be detained further there, because, Lordship, with the main, one of the accused, Lordship, who is arrested and now in judicial custody, Lordship, I had some transaction regarding supply of manpower, Lordship, in Dimapur. And in this manner, Lordship, I had to come across with him in a certain transaction, Lordship, and that I have stated in para 3 of my application. May I take your Lordship to that, Lordship?
No.
Yes.
Apart from your statement, have you submitted anything to substantiate
Lordship is
regarding transaction?
on oath, Lordship. This application has been filed on oath. That is on oath. I have stated, Lordship, what has been stated, what has been happened, Lordship, exactly, and what is that might be a cause because
Are you named in the FIR?
No, Lordship, I'm not named in the affair, and I have very honestly, I'm making a statement that yes, I had some transaction with one Sunti Das, who was arrested in connection with this case. And subsequently, the investigating authority might have come across with his statement and got.
Case diary is there. Case diary.
That is my case. So
What is your name?
my name is Bishu Rangpi, Lordship. Vishnu
Vishnu Rampi. What are the material?
For some, what reason, don't number of sub money transaction which Suniti Das is there. But for what reason the money has been given to Suniti Das, that is not, that is under investigation. But transaction which Suniti Das, he was arrested, Suniti Das.
Heard Miss P. Som, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Vishnu Rangpi, who is apprehending his arrest in connection with CIDPS case number 4/2025 under section 61(2)/3184/336 within bracket 3/340 within bracket 2 of BNS. The gist of accusation in this case is that on which date FIR was lodged? On 10/2/2025, one Bhaskar Jyoti Sharma, Chief Engineer, Water Resource Department, had lodged an FIR before the Additional Director General of Police, inter alia, alleging that a fake appointment letter containing the forged signatures of the informant was circulated by some of the miscreants to various divisions under Water Resource Department. Learned counsel for the petitioner submits that petitioner is in no way involved in the offense alleged in the FIR. However, he is apprehending arrest as he is an acquaintance of one of the arrested accused persons, namely Sunti Das, with whom he had some monetary transaction in respect of some who engaged manpower?
Both of them, Lordship, because he
In
had
respect of engaging of manpower at Dimapur for some work. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of CIDPS case number 4/2025 and has submitted that in this case, some of the accused persons were granted privilege of anticipatory bail. However, some of the bail application filed by the co-accused have been rejected. He submits that case diary reveals the existence of monetary transaction between one of the co-accused, namely Sunti Das, and the present petitioner. However, for what purpose said monetary transaction was done is still under investigation. He further submits that still under investigation. Stop. You are opposing? He therefore opposes the grant of anticipatory bail to the petitioner at this stage. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of CIDPS case number 4/2025. Stop. On perusal of the case diary, it appears that the only material against the present petitioner at this stage is that he had monetary transaction with one of the co-accused, namely Sunti Das. Apart from the said fact, there is nothing at this stage which would incriminate him in the offense alleged in the FIR. Stop. Under such circumstances, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of aforesaid case. Stop. In view of above, the petitioner, namely Vishnu Rongpi, is hereby directed to appear before the investigating officer of CIDPS case number 4/2025 within 7 days of the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of rupees 30,000 with one surety of life, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2, investigation. Conditions relating to investigation. Take it from Abhishek. What is the
Case is regarding lordship here. mm, Here lordship petitioner in fact been duped by one of Ranjan Pegu lordship, and for the purpose of availing lordship petitioner's associates money has been taken by that Ranjan Pegu. That is all here. That apart lordship petitioner neither issued any appointment, nor he posed any signature, nor any kind of, nor he is named in the FIR lordship.
but you paid money
Have paid money to
to
Ranjan Pegu. And that apart lordship, I have been served with a notice lordship that I have brought in record in by way of additional affidavit, and lordship would be pleased to.
what is the date of appearance?
Lordship.
Date of appearance in that.
Lordship
Why?
Defaulted.
What is the date?
The date was, it was in additional affidavit I have mentioned, lordship. 28/7 was the date, lordship. 28/7.
Yes. Mr. Parash.
Petitioner has not informed us that it will be moved. We just luckily come to know the names that come to know. Luckily, the case was there. That we have found out without any petition.
You serve a copy of it.
But it is not again. But in earlier dates, perhaps that there are two groups. One is Abu Hanif was reader. Today, item was 16. He was default bail because
Exceeded.
now one Abu Hanif group, one is Ranjan Pegu group. who procured the document that is not yet come to the license, but it was circulated by someone. Now, this is the person, Shankar Bhumik, who has circulated through WhatsApp. Ranjan Pegu took those documents and take printout and supplied to the candidates. He collected the money. This
Shankar Bhumik.
took the money from the candidates, given the money to Ranjan Pegu, and he through WhatsApp given those appointment letters, sending the name of different persons to Ranjan Pegu, and Ranjan Pegu took the printout and given to the persons candidates. So at this stage, this anticipatory is customer information. He has a role model.
Heard this. Yes, I am reading.
Start with,
Other
if
case,
it is so lordship, then this authority might not have issued this 35(3) notice lordship. That purely justifies that I'm not that kingpin to be in custody lordship. That is one aspect lordship. And since lordship, this notice has been issued to me, I want to duly cooperate with the investigation. I'm a resident of Assam lordship. I'll purely, and I have honestly submitted that lordship, I have been duped lordship. I have been duped, and for my associates, whoever my employees, I have given money. That is true lordship. And in fact, I became one of the victim lordship. Very
No,
honestly.
you collected money from other.
Not other lordship, all my brother, my sister-in-law, my whole family member.
So
All have become your family members.
Lordship. That was the situation, lordship. Now that Ranjan Pegu has been arrested, I want to cooperate with the investigation.
Okay, heard.
Since lordship,
now, who procured that document not yet come to
that
the light.
is lordship, that
He circulated. He through WhatsApp,
that is
but to another that person who has procured those documents. So he's
lordship here in this case, lordship, thousands of persons being implicated, and their everyday random pickup is going on. So my humble prayer, lordship, since this notice has at least been issued to me and I have defaulted because I have received it in a later part. So lordship, that may be taken into consideration, and I may be given an opportunity to appear at any stringent
I'll
condition.
go through the case that you flag mass. You flag mass. Heard Miss P. Som, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Shankar Kumar Bhumik, who is apprehending his arrest in connection with CIDPS case number 4/2025 under section 61 within bracket 2/318 within bracket 4/336 within bracket 3/340 within bracket 2 of BNS stop. The gist of accusation, quote from earlier item. Last item is item number 30. Quote gist of accusation as it is. Learned counsel for the petitioner submits that the petitioner had received a notice under section 35 within bracket 3 of BNS directing him to appear in connection before the IO in connection with the aforesaid case on 28/7/2025. However, he received the notice after the lapse of the said date, and therefore he could not appear before the investigating officer. And he now apprehends that if he appears now, he may be arrested in connection with the aforesaid case. Learned counsel for the petitioner also submits that the petitioner is in fact a victim, as he has been duped by one Ranjan Pegu, who is also one of the accused in this case of providing job of the fourth grade employees / muster roll worker, the work charge employees, work charge employees / muster roll worker in water resource department. She submits that the petitioner had collected money from his associates / relatives / employees and paid the same to the co-accused Ranjan Pego on an assurance of getting the job in water resource department. However, later on it was found that fake appointment letters were issued. On the other hand, she also submits learned counsel for the petitioner also submits that as the notice under section 35 within bracket 3 has been issued to her, to the petitioner, it indicates that the investigating agency did not require custodial interrogation of the petitioner, and he is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor, Mr. K.K. Parashar, has produced the case diary of CIDPS case number 4/2025 and has vehemently opposed the grant of anticipatory bail to the petitioner at this stage. He submits that there are materials in the case diary to indicate that it was the present petitioner who had circulated fake letter as mentioned in the FIR, through WhatsApp to various persons. He also submits that there are also materials to indicate that the present petitioner collected money from prospective candidates and handed over prospective candidates on pretext of offering job of work charge employee / muster roll worker in water resource department. He did so in connivance with the other co-accused, namely Ranjan Pego. What happened to Ranjan Pego? He is arrested.
He is arrested long back.
Who has already been arrested. So I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Flag mark this. I'll go through the case diary. Take remaining part in chamber.
Typing item 15.
In this case, my lord, with all respect, my lord. Here, my lord, there is a coke factory, my lord. In that factory, my lord, two group of laborers clashed, my lord. Two group of laborers clashed, and unfortunately, one, my lord, employee, my lord, he expired, my lord. Now, my lord, what I have been told, my lord, if the CCTV footage is there in the case diary, I was not even present at the place of occurrence at the time of occurrence, my lord. The
Oh.
FIR does not name me, my lord.
Who are you, Ajay Mahato?
Ajay Mahato, my lord. I am a businessman, my lord. Only there was a settlement between the company and the deceased that we have annexed that occurs as page, my lord, 39. I arranged that settlement, my lord. And there is another character by my name, not my title, my lord. Kindly, my lord, my name is Ajoy Mahato, my lord. And the other character is Ajoy Giri. After the occurrence, he fled to Bihar because it is common knowledge in the locality, my lord, that he was amongst the group. 3 have been arrested.
Ajay Deuri,
No. Ajoy Giri, my lord.
Giri. Okay, okay.
Maybe Ajoy Deuri. If
Deuri or Giri?
Giri. Ajoy Giri, my lord. I remember, as has been told to me, my lord. Ajoy Giri.
Okay.
And the CCTV footage, it is not there, a short death, my lord. I am otherwise absolutely not involved, my lord. If it is there, lordship may dispose it of, my lord.
Several witness took the name of 4 or 5 persons, my lord, and among those persons, Ajoy name is there. So
Oh.
I need a report from the IO.
Oh, no.
Whether
Yes.
he is
What I'm
Ajay
saying, my lord.
Giri or Mahato.
No, can it be specific, my lord?
Yes.
Whether it is Ajoy Giri, that will be otherwise
Heard
police, my
Mr.
lord.
B.K. Mahajan.
And a CCTV footage, kindly, my lord, of the occurrence. It's a company, my lord.
No CCTV footage we cannot
No,
insist.
if any, my lord. Because
No, if there is anything, they will produce,
they may not
but we
produce, my lord.
we may not direct.
But can it be, my lord, Coke company? CCTV is there because of otherwise, my lord, injury and
That way,
everything.
we will be participating in investigation.
As your lordship pleases, my lord.
Heard Mr.
This
B.K.
is our
Mahajan,
submission, my
learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, Sri Ajay Mahato, who has been detained behind the bars since 27/2025 in connection with Sonapur PS case number 95/2025 under section 109/117 within bracket 2/130 within bracket 130/3 within bracket 5/3 within bracket 3 of BNS along with section 14 of Child and Adolescent Labor within bracket Prohibition Regulation Act 1986 and added section 103 within bracket 2 of BNS and section 3 of Scheduled Caste and Scheduled Tribe within bracket Prevention of Atrocities Act 1989. Learned counsel for the petitioner has submitted that the accusation in this case is that in a group clash
clash between 2 group of laborers.
In a clash between 2 groups of laborer, one person expired. He submits that the petitioner was not available.
Exactly.
Was not there in the place of occurrence of alleged offense, which may be verified by examination of CCTV footage available at the place of occurrence. He also submits that he came to know that another person by name of Ajay Giri was present there, and as his name is same as the first name of the said person is same as of the present petitioner, he has been falsely implicated in this case. On this, learned additional public prosecutor has submitted that though the case diary which is available before this court indicates that one person by name Ajay within inverted comma was there was seen by several witnesses at the place of occurrence of offense. However, it is not clear from the said case diary whether the said Ajay is the present petitioner, that is Ajay Mahato, or the person to whom the learned counsel for the petitioner is referring to, that is Ajay Giri. Stop. He therefore seeks some time to get a report from the investigating officer regarding this fact. And the prayer is allowed. Let a report be called for. But whatever is there, it will be there in the case diary, from where he will give report. Further investigate, you have to send back the case diary. And after.
Anything.
Well,
can it be required? All of form
let the case diary be sent back to be called again after updation. Let this case be listed up. 19th. 19th.
Can it be 14th? He'll try.
14, police will be busy with.
As your lordship pleases.
Let it be 19th. 19th.
Item 19. Here, my lord. May
Yes.
I am sorry, my lord. Here, my lord, we said that we'll be filing an affidavit. And whatever queries lordship made, if I remember rightly, my lord, to the best of our ability, we have answered them, my lord. Can I just place it, my lord? And there, because if I read the entire affidavit, too lengthy, my lord. Queries were, my lord. If there is a primary.
What is the case? You are Hemen Sharma.
That, my lord, Bandhan Bank case, my lord. In my lord, accounts, money were deposited.
Some mule accounts were created.
My lord?
Some
exactly.
mule
Name I don't know, my lord. Exactly. That technically that is the name.
Okay.
That is the name, my lord. Here, what has happened, my lord? I am the branch manager, my lord. Now, my complicity, first of all, my lord, I was granted the privilege of ad interim, ad interim pre-arrest bail. Even prior to my arrest, I was called, I appeared, my lord. That we have stated in our additional affidavit, with all respect, my lord, para 4, page 31. Petition from DPM. Para 4 to Kyo question. Para 4 Kyo. I'm sorry, my lord. Para 4 is subsequent to pre-arrest bail on which dates I appeared. At para 2, we have stated, my lord, that first we appeared when police called me, my lord, on 16/5 and made himself available. Then I was interrogated. Then I was late up. Then I came before this honorable court seeking pre-arrest bail. I got pre-arrest bail. That part is enumerated at para 4, page 31, my lord. That a petitioner begged to state that the person to the aforesaid order dated so and so, he appeared on 23/5 before the investigating agency and cooperated in the investigation of the instant case. Thereafter, on 27/5, 29/5, 30/5, the investigating agency visited Nalbari branch and the petitioner also cooperated with the investigating agency. My lord, CCTV footage and everything is there, my lord, and produced all the relevant documents as per instruction of the investigating agency, and the same were already seized by the investigating agency in connection with the instant case. Moreover, on 31/5/25, the petitioner provided some more documents were sought, my lord, were provided some more relevant documents to the investigating agency at Motorpol police station through one Dipankar Bormon. The copies are, my lord, with all respect, my lord, those occur at case keta koi dia. Case keta kwa. I'm sorry, my lord, I'm taking a minute.
Annexure 7.
Next again. Page 44 to 49. Page 44 to 49, my lord. Yeah, yeah. Page 44, my lord. This is dated. This is dated 27/5, my lord. At the top, lots of has seen, my lord. 44, my lord.
Yes.
Date and time. Location Bandhan Bank, Nalbari.
What is this?
They came and, my lord, came to the bank.
Teaser list.
Caesar list, my lord.
What is your submission?
No, my lord, only that I cooperated.
After getting interim bail.
Even prior to that, I was called, I appeared. 16-2. Averment supported by affidavit, my lord. Then I took pre-arrest bail. Then these are the documents, my lord. 44, 45. Thereafter, I have never been called, my lord. And my one document we have failed to annex. My mobile phone was also seized. My lord, with all respect, my lord, that is White Caesar list. That took on 10/6/25, my lord. This is placed before your lordships, my lord. That is not annexed to the application. Thereafter, we have never been called, my lord. I have never been called, my lord. So regarding non-cooperation, if any someone is shown that I received it, I did not appear, then it would be in the fitness of things, my lord. I appeared on every date I was called for. They came to Bandhan Bank on several dates. We cooperated, and subsequently on that particular day, my mobile phone was sought for, and that was seized, my lord. This is the non-cooperation part. Manada, we have, my lord, we deny it totally, and we have made this in this paragraph. We have stated everything, my lord. Then regarding the scam, my lord, the account was opened. There were 6 other accounts. I'll state regarding them as well, my lord. Regarding this account, with all respect, my lord, was opened on. I'm stating that lordship, but kindly have a look at page 22 and 24. Account to open kora date to ki khali. I'm placing it, my lord. Account was opened not by me. Oh, I'm sorry, my lord. Page 76 of the additional affidavit.
By one of your employee, Dhiraj Khalid.
No, my lord.
Page 81.
Nobonita Horma, my lord. When the account was opened, my lord.
Page
81.
Of the additional affidavit.
Exactly, my lord. It would be opening or what? By one store. What? Nobonita Horma Kun. France sales executive. BSc means sales executive. Opened by the BSc, possibly branch sales executive, Nobonita Horma, my lord, on 5/12/24. Page 81, my lord.
Open means verification was done. Verification was done by.
Yes, money verification was done. On that, it was opened, my lord.
Yes.
Thereafter, my lord, I come to the FIR, my lord, with all respect, my lord. Aruki, sense to too many things, my lord. Oh, I come to the FIR, my lord. FIR kono case tulbo. More petition kon dia mo likhisilu no. Be very careful, brother. Lordship, may kindly have a look at page 11/12. Account was opened by the branch sales executive, my lord. In that particular date that I have stated, my lord. FIR is at page 11, my lord. FIR, my lord. Allegations are, my lord, like this. It goes on and on against all, my lord, inclusive of me, my lord. My name appears at 2. If I read it in totality, I think my name appears in the second page. ID regarding change of ID, my lord. I have never permitted the authority of Bandhan Bank, Nalbari branch or his branch manager, Hemen Horma, to change the ID and email ID and my lord mobile number. This was done at the behest of Pranab Bayan himself, my lord, that we have annexed, my lord, with all respect, my lord, by on his own application.
No, the case is that some of the bank officials and someone middleman took his Hemant Sharma's signature on blank formats.
Yes, as per Hemant Sharma, my lord.
That has been utilized to change the email and phone numbers.
Yes.
So it is not he himself opened.
Exactly. If that is so, regarding opening of account, it was verified that that lady, my lord, she has been never called by police. I am on pre-arrest bail. And regarding this change of number, if his signature is not there, we have annexed it, my lord. Let it go to FSL, my lord. Have I made my position clear, my lord? And I did not allow it to change. There are other, even after freezing of the account, this particular informant sought for release of money, which I kept pending, my lord. All the down below my officials allowed it, my lord. That document also I'll place. Bank document, my lord.
Release of money means?
That in that account, certain amount of money, huge amount of money from some unknown sources were deposited. Have I made my position clear, my lord? Hemant Sharma, if it is not his signature, my lord, that FSL will prove. He sought for release of that amount. From that I'll come later on, my lord. Kindly see regarding this part, opening ID, it is his signature or not. I'm just placing it, my lord. That is in page number. The application number to
Page 74.
Page 74, my lord. It is page page I'm taking 1 minute, my lord. Send your phone number on so and so. Allowed by area manager. 21 to 24, my lord. Main petition.
You, Mr. Mahajan,
my lord,
you take time.
I'm sorry.
It appears that you are not properly instructed.
No, my lord, I have taken page wise, my lord, one main, my lord, application. Certain papers are annexed there, certain in the additional affidavit. Because of paucity of time, possibly lordship's not mine, my lord. I'm in a hurry, that's why I'm pressing it like this. But these pages are absolutely all right, my lord. I can press it right now. With all respect and full reverence, my lord. My lord, that regarding change of email and mobile number, if he did not do it on blank papers, it was done, then my lord, the signature has to go to FSL. Kindly see, my lord. This occurs at page 22. Pranab Bayan at page 22, my lord. Regarding change of key.
Change of phone number.
This is regarding change of phone number, my lord. Applied by Pranab Bayan, contrary to whatever he has stated, my lord. And it is kune thik kore dise. Dheeraj Kolite ki korche?
Yeah. Password.
Korise ki?
Dheeraj Kolita is one of the co-accused.
I don't know, my lord. I'm sorry, my lord. I'm sorry, my lord. Dheeraj Kolita approved it, my lord. And this Pranab Bayan has signed it, my lord. And Vipul Haloi, assistant branch head, he cleared it, my lord.
So you want to say that you don't have any role?
No, I have a role. I being the head, my lord. But regarding
no, what is your submission?
My submission regarding this change of numbers, whatever documents came, at the end I may have endorsed it, my lord. But it was carried out by my lord, first informant himself. Thereafter, my lord, it was by one co-accused, it's bank employee negi. My lord, Dhiras Kolita, bank employee, my lord, and endorsed by, allowed by, not me, my lord, Bipul Haloi. You get Dhursen name. Bipul Haloi, my lord. If the signature is false, I cannot be liable, my lord. I did not allow it, my lord.
Yes.
This
The
is the
identity of customer was to be verified by Dhiraj Kolita.
no, he verified it, my lord. He verified it, my lord. Dhiras Kolita, assistant branch head, no? Customer relation officer. Or it will allow one person. Allowed by assistant branch manager, my lord. He is below me, my lord.
It was approved by you.
Yes, yes.
No.
It was approved by you. It was verified by Dhiraj Kolita.
Yes. Approved by Bipul Haloi, my lord. Not Hemant Sharma. It will Bipul Haloi bole kenai gom pala. Affidavit likhiso. In my lord paragraph, Bipul Haloi sohita man. My lord, we have stated that para 5, my lord. Main petition.
No,
Additional affidavit, page 32, my lord.
Yes.
May I read, my lord?
Yes, your submission is that it was change of phone number and change of email was not verified by you.
No.
It was
no
very,
question
no,
of very.
no,
Exactly.
let me make
I'm
myself
sorry.
clear.
I'm sorry.
It was verified by one of your employees,
Exactly.
Dhiraj Kolita.
No, not employees, my lord. Junior officer, my lord.
Yes.
Bank employee.
One of the bank employees, Dhiraj Kolita, and
Dhiraj
it was approved by assistant bank manager.
My lord, that name is, Bipul Haloi. You have stated in para 5, my lord. There are petitioner beg to state that as regards the allegation of changing of the mobile number and the email ID connected with the account of the
So
informant
what is your
concerned.
submission? You don't know. You don't have a role.
I don't have a role, my lord.
Okay, that is
Regarding change of numbers. And that is a lie in the first information report that it was changed because signing in bank papers, it was, my lord, that is his ploy, that it was unknown to him. If the bank number, email number were changed at his behest, my lord, it would go to him. And when it was changed, we are sanguine. Application nahi ami. Tata message goes to him. Message goes to him, my lord. That can be verified, my lord. Thereafter, culpability will come, my lord.
okay. Now, what is your submission?
My submission is, my lord, that in the affidavit, in the first information about whatever has been stated by the first, another thing is there, that his bona fides are not right. He claimed it was changed behind his back, but not behind his back. Exactly in the open it was, he applied for it. If it is not signature, it is not his signature, then FSL will prove it, my lord. And even if it is not his signature, I am not culpable, my lord. Culpability is not attributed to me.
No, he is not saying that it is not my signature. He's saying that my signatures were obtained on blank format.
But is it a blank format, my lord? Can it be typed out later, my lord? Whatever we have annexed, my lord, is a typed format. Other signature has to be forced, if that is so. And verified by verification. By Dhiras Kolita, my lord. It is not a blank paper.
Okay. What else is your
It's a
submission?
pro forma, my lord. With all respect, my lord.
Yes.
And thereafter, regarding email, the same thing happens, my lord. My lord, here, Pranab Bayon, signature Bayon store, verified by Dhiras Kolita, signed by Bipul Haloi. You have additional, sorry. Branch said, assistant branch said. Is the assistant branch said, and his name is Bipul Haloi, that we have categorically stated in para 5.
Okay.
I have no role to play, my lord. Absolutely. Okay. This is one part, my lord. How are we going to? Really, he's doing person. Method episode diva. Para 5 page 32. Okay. Now, my lord, with all respect, my lord, let us come to page 33 of the additional affidavit, of the additional affidavit, my lord. Page 33, paragraph 7, my lord.
Yes, what you want to submit?
That after the account being frozen, we got an email because there is in the banking system, my lord, no branch can ascertain if there is any online transaction, my lord. Offline can only be the branch manager or any employee can come to know about it. It is only known in online transaction in any bank, my lord. That I have asked. That can be verified, my lord. Any branch, my lord, in a short duration, it cannot be found out. The main computer is there in the head office or whatever is the locality head office, my lord. It goes there. That our higher up informed us that there is huge transaction of money in some 4 or 5 more accounts, my lord. We are told to do inquiry. We incurred. Thereafter, frozen those accounts, my lord. After those accounts being frozen, this applicant sought for release of some money from his account. It was allowed by all my juniors. I kept it pending, my lord. That will come later on. Can I read this paragraph, my lord?
Yes, which paragraph?
Para 7, page 33. That the petitioner beg to state that in the instant case, the transacting monitoring unit of the Bandhan Bank, Kolkata, on 27 to 25 in email was received in the Nalbari branch from the transacting monitoring unit, Bandhan Bank, Kolkata, informing the petitioner's branch that during account monitoring activity, they had detected an account bearing number so-and-so of the first informants pertaining to their branch, which seemed to be suspicious, and requested the petitioner to conduct field verification, verifying KIC documents, confirm the source and application of fund in account in question, etc. Upon receipt of the email in question, the petitioner made an inquiry and conducted field verification. And by email dated so-and-so at 6:05 p.m., a field verification report was submitted to the head office, stating that unexpected suspicious debit and credit transactions were done and accordingly recommended to freeze the debit by making the same. Debit freezer was suggested by me upon doing field verification. And that is it, my lord, with all respect.
Okay, I'll check it.
51. Can I show the page, my lord?
Yes, page
50. I'm taking a minute, my lord. 50. This is the mail which came to us. 50, my lord. Mail from the office which can detect online transaction, legal transaction, illegal transaction. That is the monitoring head, my lord. That is in Calcutta, my lord.
Okay.
Page 50, that letter was given to me. We have, after field verification, my lord, can I read the contents?
No, I accept that.
Yeah.
That you came to know after a report from transaction monitoring unit that there is some suspicious transaction in this account.
We
that is accepted. Then what is your submission?
No, we did it. So far as I am concerned, my
Your
lord,
submission is that you were unaware about.
regarding any bank, my lord, that with all respect, my lord, online transaction cannot be detected by that bank, even Punjab National Bank, my lord.
Yes.
Because that is why many cases come up where, my lord.
That I accept. Therefore, there is a transaction monitoring unit.
Yes, my lord.
Of a bank.
Exactly. I have understood. These documents I have placed, my lord.
Okay.
It was not within my knowledge. Thereafter, my lord, certain points lordship raised that I have clarified, my lord. Then this gentleman one lie is apparent, my lord. If his signature was on blank papers, that cannot be, my lord. It is a printed form.
No, his statement also says that the bank officials took his signatures on some empty forms and blank sheets.
Empty forms.
Forms.
Is it empty, my lord?
It was empty when he signed. That is the.
Oh, my lord, that form possibly, what the form we have annexed.
Investigation would reveal it.
Investigation would reveal, my lord. Yes, very much. Let them investigate, my lord. Whether it was done. Another aspect, kindly see, my lord. When it was frozen, my lord, David Fridge was there. David Fridge was there. He cannot withdraw money. Thereafter, what he did, my lord, he files an application before the bank. The same first informant, my lord, saying that the account should be defrozen. Only idea. Type copy is page 74, my lord. Page 74. Sir, I am taking a minute, my lord. Account frozen, no? Huh? Oh. Yes, my lord. 74, my lord.
Yes.
This is to inform you that I Pranab Bhuya or Pranab Bayon. This is the language, my name so and so. I am unable to transact the account due to restriction. This is a business purpose account. Kindly remove the restriction on urgent. If he knew the illegal money was there, how can he pray for defreezing it, my lord? Pranab Bayon, this is the typed copy. And this is, my lord, with all respect, typed copy, Pranab Bayon. If the Sui card, it's a 9, no? Pranab Bayon. Same, my lord. Paper. But it was kept pending, my lord.
Okay.
Meaning thereby, one has to come with clean hands. In the FIR, if his signature was not there, then it is, my lord, he is correct. Otherwise, if he pays for changing his mobile number, changing his email, and thereafter claims that it was behind his back, that would be dangerous, my lord. But if his signature was frozen, that part I never knew, my lord, as your lordship has told me, my lord. Now, that is to be verified, my lord. He has not come with clean hands if his signature is there. And thereafter, this letter, which has been kept pending, my lord, apparently shows, with all respect, my lord, if it is his signature, my lord, then for defreezing the frozen account, he paid himself after knowing fully well that ill-gotten money was deposited into that account. Have I made my position clear, my lord?
Yes.
And another aspect, my lord, and my lord, customer relation officer, no? Arrested persons, my lord, customer relation officer Dhiraj Kolita, he is my employee, not my employee, my lord, my bank's co-employee, my lord, junior to me. I may have mobile communication with him, my lord, or WhatsApp communication, my lord, but no communication as regards these illegal accounts. If it is detected, it can be placed before your lordship by the investigating agency. Have I made my position clear, my lord? If some co-accused is there, if I have some illegal communication, I'm meaning any communication regarding the subject matter of the case, if it is there in the case diary, my complicity would be there. Have I made my position clear, my lord?
Yes.
Having contacts with him is no offense, my lord. He is my junior employee. Prior to his arrest, I have not been arrested. I have not been suspended. There's a departmental bank inquiry, my lord, inside. I'm still in service, my lord. And with him, I had contact. And second man, one was outsourcing, my lord, SDFC employee. To naam ki? Konkon ki? Konkon Das, my lord. He is an SDFC employee, and with SDFC, Bandhan Bank has a tie-up regarding insurance, my lord. I had contact with him till he left our bank, my lord. Sure too. December 2024. Thereafter, I have no contact with him over telephone, my lord. And regarding these illegal transactions or this subject matter of the case, if they can produce, my complicity would be proved. Otherwise, not, my lord. Regarding the subject matter of this case, my lord, this account and 4 or 5 other accounts. Oh, by the way, my lord, regarding the 4 or 5 other accounts, similar set, my lord. Head office informed us. I did field inquiry. I have annexed everything, my lord. I did field inquiry, sent report, and those were frozen, my lord.
Okay.
And another character, my lord, ki naam tumi bola? Hassan Basir. He is not a bank employee, not an HDFC insurance employee also. I have no connection with him, my lord. I have never seen him in my lifetime, my lord. This is the instruction. Have I made my position clear, my lord?
Yes.
It Hassan Basir, my lord. He has also been arrested, I have been told, my lord. That's what he said. Whether it took information. Information delay. Corporate. Well, there are some authorities which my intent to place before your lordships, my lord.
Yes.
With all respect, my lord. My lord, here, my lord, after being rejected by the IS officer lady, my lord, he provided a disability certificate, my lord. It was in the news very recently in 2025, my lord.
Wow. On what point you are relying this?
Exactly, my lord. Read that paragraph, but absolutely in consonance, in connection with this case, my lord. Same subject matter, my lord. I'm reading from the first page, my lord. The said application for
No, you need not to read. You just point out.
No, one
why are you relying this?
I rely because of this line, my lord. My lord, cooperation and non-cooperation. It is stated here, my lord. Kindly see. Para 8. Par contra, learned counsel appearing for the respondent vehemently objected to the grant of relief to the appellant herein, in as much as the appellant has not been cooperating with the investigation, although she may be appearing before the investigation because it is barred by Article 23, my lord, which she has been summoned to do so. Learned counsel conduct the allegations against the appellant herein are serious in as much as she has exceeded, goes on and on, my lord.
But in this case, while granting relief, why relief was granted? No reasoning is there.
No reasoning.
This is only submission of counsel.
Well, this is considering a circumstantial record. Our view that the appellant is entitled to. It was rejected by the High Court. Supreme Court allowed it only because the reason that, my lord, she appeared, she did not cooperate. Allegations of non-cooperation is in your lordship's order sheet. This is how
but why are you relying this judgment?
I am relying this. Kindly see this line, my lord. Par contra, learned counsel for appearing for the respondent vehemently objected to the grant of relief to the appellant herein, in as much as the appellant has not been cooperating with the investigating. Although
that is this.
Because I appeared every day, whatever day I was sought for, I appeared. I gave all the documents. Everything was seized. Even then, there is an allegation that I was not cooperating. Because there is no document calling me on any further date that I did not appear. That is not the case. I appeared, but the allegation of one order is there, my lord, lordship's order. Can I just read it and place it before your lordships, my lord? So this is order is a 2625.
Okay, your submission is that if pursuant to interim bail,
yes, my lord,
if the petitioner cooperates, in this case, petitioner is on interim bail.
Yes, my lord, I cooperated.
Then it may not be a ground for cancelling his.
Exactly, my lord.
Okay.
My lord, not cancelling, rejecting it, my lord. Have I made my position clear, my lord? As I am on interim bail, my lord, with all respect and folded hands, my lord, has been cooperating, submitted that the petitioner has not been cooperating with the investigating officer. But I cooperated, my lord. It may be, my lord, that I kept my mouth shut because of Article 23. I cannot be a witness against myself, my lord. If they tell me to implicate myself, my lord, I do not do that. That is not non-cooperation, my lord. And there is no summon pending against me, received by me or my bank, that pursuant to that I did not appear.
Okay.
Have I made my position clear? That is why I have cited it, my lord, with all respect and forbearance, my lord. Thereafter, another authority, my lord. Do you know what to This is Podip Soma. This is also 25, my lord. I thought to be relevant, my lord. I'll leave the only relevant paragraphs, my lord. Listen again. Oh, para 18, my lord.
Yes.
May I, my lord? However, considering the nature of the allegation and the fact that the matter is to be investigated, here also it is to be investigated, my lord, whether it was Hemant Sharma's signature or not, my lord, or by somebody else, primarily based on documentary evidence. Here it is absolutely based on documentary evidence, my lord, or computer data, my lord, same as documentary evidence. The court is inclined to grant the relief of anticipatory bail to the appellant. The offences alleged pertain to exercise of administrative discretion in the passing of an order rather than direct physical involvement. What is my direct physical involvement? In any other criminal act regarding custodial interrogation. The prosecution has not demonstrated any necessity for custodial interrogation of the appellant beyond security of official record, beyond scrutiny of official record. That can be done without placing him in detention. Thereafter, this is important. Additionally, in the appellant has expressed his willingness to cooperate with the investigation, and no material has been placed before this court to suggest that he has evaded or obstructed the investigation in any manner. I have never obstructed. I went on every date I was called for, even prior to PRS bail I went. Everything was seized for me. Thereafter, I was never summoned.
Yes.
Furthermore, it is well settled that anticipatory bail can be granted where custodial interrogation is not essential, particularly in cases where the allegation hing on official record. Here, absolutely on official records and the presence of my lord so and so. Thereafter, last lines, my lord. The grant of anticipatory bail is just accordingly. We allow the appellant to cooperate with the and will further cooperate, my lord, and so seek a report as to whether the signature is true or not in our application, my lord, with the investigation. And when required, he shall not be taken into custody subject to condition imposed hereinafter. That is why I have placed it, my lord, with all respect and forbearance, my lord. And what Matre says, my lord, this opened the floodgates, my lord. Metro Lordship knows more than me, my lord. There, it is reported in, my lord, 2011, Mana Sitaringa, Satlinga, Matre, my lord. This opened the floodgates, my lord. Only 2 lines I'll read, my lord. Kindly.
Para?
Para, Para 88 and 89, my lord. The gravity of charge and the exact role of the accused must be properly comprehended before arrest. The arresting officer must record the valid reasons which have led to the arrest of the accused in the case diary. This is neither in the statute, but this is an Article 141 authority, my lord. Although not there in the statute, even it is to be followed. In exceptional cases, the reasons could be recorded immediately after arrest, so that while dealing with the bail applications, the remarks and observations of the arresting officer can also be properly evaluated by the court. This is never done in post-arrest cases. This paragraph is important, my lord. 89, I am reading from the 3rd line. In cases where the court is of the considered view that the accused had joined investigation, in my understanding, I had joined investigation. If there is proof that I received summons, I did not appear, then it's a different case. He is fully cooperating with the investigating agency and he is not likely to abscond. I'm a bank manager, I'll never abscond. In that event, custodial interrogation should be avoided. Okay. I'm on interim bail, my lord. This is the case, my lord. Exactly, my lord, bank. It was rejected by the Bihar High Court, my lord. Many crores, my lord. That too, here, my lord, the difference is the account was, money was deposited to the wife's account of the bank manager, my lord. Have I made my position clear, my lord? Huge amount of money then my lord, FIR has been registered, it will be, it was rejected by the, my lord, it will be too lengthy, my lord, Patna High Court rejected, then Supreme Court said, my lord, with all respect, Supreme Court, my lord, with all respect, my lord, that occurs at some pages later, my lord. The specially petition is against rejection of anticipatory bail by order that so and so the petitioner has been protected. Again, that was interim in the apex court, my lord. Subsequent to rejection by the Bihar High Court, which has been continued till then. It was apprehended on behalf of the investigating agency that it was the case on behalf of the investigating agency that after obtaining the interim protection, the petitioner is not cooperating with the investigation and has not appeared before the investigating agency. Kindly see, I have appeared. Here he did not appear. Considering the above, the court passed the following order. Even then time was granted, my lord. Learned Counsel appearing on behalf of the state has vehemently submitted that after obtaining interim protection from this court, the petitioner is not cooperating in the investigation which is disputed by the Learned Counsel appearing on behalf of the petitioner. Like me, my lord, with all respect, my lord. Thereafter.
Okay, you have made your point. That
Yes.
if the petitioner is ready to cooperate,
Yes, my
his interim bail should not be
obstructed, my lord.
should not be vacated.
Vacated or, my lord, this further investigation not further. Proper
And
investigation.
your submission is that you are cooperating.
I am cooperating and proper investigation. If the signature is somebody else's, my lord, have I made my position clear?
Okay.
There has to be a definite finding.
Yes, Mr. Sharma. No, on same point. If I allow you, you will continue bringing authorities on same point. On a particular point, one
What
authority of
point I
Supreme.
also forget. I do so many cases.
Yes, Mr. Sharma. You have made all your points or anything left?
I'm happy with all respect.
Yes, Mr. Sharma.
What I'm given to understand, Lordship, I have to satisfy your Lordship regarding the necessity of custody intervention.
Yes, so their main point is that he, after getting interim bail, appeared before the investigating officer. Thereafter, he was not summoned to appear, and he is ready to cooperate. And if he is ready to cooperate, his interim bail should not be vacated, and it should be made absolute. This is, and second is the investigation is based on documents only. So that can be done without his custodial interrogation. These two may. And others is that you have heard that that this transaction came to his notice only after he got report from Kolkata, and he took immediate steps as required on his part. That is his submission. And the verification of the person requesting change of email and change of phone number was done by his junior staff, and it was approved by assistant manager. So he was not in the know of the facts. That is his main submission. And therefore, his interim bail should not be rejected. How you counter these?
Regarding Lordship, the allegation of his juniors being in the know-how or they are shifting the blame to the juniors, Lordship, all those bail applications Lordship has granted the case and rejected all their bail, including Lordship Dhiraj Kolita and the complicity of the other person from the HDFC bank. All those bails were considered by Lordship and their bails were rejected, finding materials in the case then. And that apart, Lordship, their statement.
No, Dhiraj Kolita was responsible to verify whether the person applying for change of number is the same person or not. To whose number the mobile phone was changed ultimately? Okay, yes.
All those are paying employees. Dhiraj Kolita was the paying employee. And Konkundas was the HDFC person, Lordship, who was the mediator to the sort of broker, Lordship, who both the customers and the main accused, who happens to be the present petitioner, Lordship. So his bail application was also rejected. And Lordship will, other thing is Lordship, regarding Lordship, the regarding the non-compulsion, should I start Lordship or should I, as your Lordship says, Lordship, I will place on those. Which query should I put out first?
No, what are your grounds for objecting
Yes.
anything?
He has appeared before the IO Lordship. That is not not in question, Lordship. I have never said that he has not appeared, Lordship. But whether that is cooperation or not, Lordship, or whether custodial interrogation is necessary or not, that I have to put up before your Lordship.
Yes.
Yes. Now, Lordship, this transaction, whatever has been done, Lordship, in the curve of this economic offense, Lordship, altogether there are 5 victims as of now. All of them have raised complaint and those are treated same effect. These 5 persons, Lordship, has already seen are 4 persons, Lordship, and they do not have any business except one, and that is Pranab Bai. He has a small shop, Lordship. Other 4 persons, they are not businessmen, and they do not have any commercial establishment. Now, Lordship, when their accounts were transacted, Lordship, this amount was around 13 crores till now, Lordship, which has been detected. Thereafter, Lordship, when investigation was done at the initial stage, Lordship, their statements were taken, the informants, complainants. Thereafter, Lordship, all those anomalies came up. Now, Lordship, when the banking procedures were seen, Lordship, their Lordship, all the complexity of the present petitioner came into force. Lordship, because in a layman terms, Lordship, in a branch, in a banking branch, Lordship, of a small town or wherever, Lordship, at the end of the business day, Lordship, it is the responsibility branch manager to prepare a assets and liabilities on what amount has been transacted in the credit side and the debit side. That is the normal practice procedure, Lordship, of all banks concerned. Now, Lordship, in a small bank, Lordship, this happens to be in the Nolbari branch, Lordship, small banking transaction, Lordship, in 4 or 6 months, Lordship, all those transactions happened in all those accounts. There was a suddenly rise of very huge amount, Lordship, as I have already pointed out. 1 crore transaction was done in a single day. That is not possible on 2 counts, Lordship. One is, Lordship, if there is an unusual transaction of a huge amount, Lordship, it gets automatically noticed by the branch manager as well as the, Lordship, main crime
That monitoring authority.
And it also comes to the notice of the branch manager, Lordship. Second is, Lordship, for executing single transaction in crores, Lordship, there has to be a special ID which has to be given to an account, Lordship. That is corporate ID, Lordship. Without that, in a single transaction, 1 crore rupees or more cannot be transacted in a single transaction, Lordship. Now, who gives the corporate ID, Lordship? The branch manager. And this fact, Lordship, was not disclosed by either him, and it was not disclosed in the initial investigation. After interrogating him, Lordship, all these facts came up. Now, Lordship, it has become all the more necessary for custodial interrogation, Lordship, because this being a technical crime, Lordship, economic offense, all this know-how, Lordship, he is still working in the bank, Lordship. And regarding this, Lordship, commercial transaction also, Lordship, if I may just point out, Lordship, corporate ID.
No, when he is subjecting himself to interrogation.
He had never disclosed regarding the corporate ID. In his statement also.
What is the difference between custodial interrogation and interrogation otherwise?
No, I'm not on that. What I'm trying to impress upon your Lordship is that his statement was taken. He has really stated it. I'm not objecting to that, or I'm not saying anything against it. But Lordship, this aspect of the investigation, that there are certain facts which cannot be unearthed with simple interim protection. For that purpose, only custody interrogation is necessary. That is what I'm trying to submit.
No,
Why?
how it can be distinguished? Is there any authority?
Saving it for the last 30 years. This is Lordship 2019-9 SCC 24. It also relates to an economic offense. If Lordship kindly comes to 66, Lordship. I will skip Lordship, will kindly come to 69, paragraph number 16. Grant of anticipatory bail in exceptional cases. Paragraph 16. I will not-
Yes, yes.
Ordinarily, arrest is a part of procedure of the investigation to secure not only the presence of the accused, but several other purposes. Power under section 438 CRPC is an extraordinary power, and the same has to be exercised sparingly. The privilege of the pre-arrest bail should be granted only in exceptional cases. The judicial discretion conferred upon the court has to be properly exercised after application of mind as to the nature and gravity of the accusation, possibility of the applicant fleeing justice and other factors to decide whether it is a fit case for grant of anticipatory bail. Grant of anticipatory bail decide whether it is a fit case for grant of, grant of anticipatory bail to some extent interferes in the sphere of investigation of an offense, and hence the court must be circumspect while exercising such power for grant of anticipatory bail. Anticipatory bail is not to be granted as a matter of rule, and it has to be granted only when the court is convinced that exceptional circumstances exist to resort to the external remedy. Now, Lordship will kindly come to 72 for a moment, Lordship. It states the scope of 438 CRPC, Lordship. We are conscious of the fact that legislature intent behind the introduction of section 438 CRPC is to safeguard the individual's personal liberty and to protect him from possibility of being humiliated and from being subjected to unnecessary police custody. However, the court must also keep in view that a criminal offense is not just against an individual, rather the societal interest is at stake. Therefore, a delicate balance is required to be established between the two rights, safeguarding the personal liberty of an individual and the societal interest. It cannot be said that refusal to grant anticipatory bail would amount to denial of the rights of conferred upon the appellant under 21 of Constitution India. Now, Lordship 74, that is the most important paragraph, Lordship. 74, next page, Lordship. Ordinarily, arrest is a part of the process of the investigation intended to secure several purposes. There may be circumstances in which the accused may provide information leading to discovery of material facts and relevant information. Grant of anticipatory bail may hamper the investigation. Pre-arrest bail is to strike a balance between the individual rights to personal freedom and the right of the investigating agency to interrogate the accused as to the material so far collected and to collect more information which may lead to recovery of relevant information. That is exactly my point. And Lordship, it has referred the case of Anil Sharma where this paragraph is relevant, Lordship. We find force in the submission of CBI that custodial interrogation is qualitatively more elicitation.
Where are you reading?
This quoted in 74, Lordship, paragraph 74.
Yes, yes.
Yes, and State versus Anil Sharma.
Yes.
That, Lordship, the relevant portion, Lordship. We find force in the submission of CBI that custodial interrogation is qualitatively more elicitation oriented than questioning a suspect who is well ensconced with a favorable order under 430 of the code. In a case like this was also in.
What is the meaning of this elicitation oriented?
Where information is sought to be gathered,
okay.
The material facts. In a case like this, effective interrogation of a suspected person is of tremendous advantage in disinterring many useful information and also materials which would have been concealed. Success in such interrogation would elude if the arrested accused person knows that he is well protected and insulated by a pre-arrest bail order during the time he is interrogated. Very often, interrogation in such a condition would reduce to a mere ritual. The argument that custodial interrogation is fraught with the danger of the person being subjected to third-degree methods needs to be countenanced for such an argument can be advanced by all accused in all criminal cases. The court has to presume that responsible police officer would conduct themselves in a responsible manner, so and so. So that is exactly my point, Lordship. These are technical issues related to an economic offense conducted by a bank manager who has all the authority in him to manipulate records and everything, Lordship. If now, Lordship, from the investigation so far, this corporate ID has come into court. How was the corporate ID given? And Lordship, if I may just add, corporate ID to a bank account is given to only business enterprises. None of them have bank, none of the 5% have any sort of business except one, and that to a small shop. How it was done, Lordship. And then, Lordship, coming to the here also, Lordship, the paragraph 75 is also relevant, Lordship. I will not read into that, Lordship, but it relates to custodial interrogation and the necessity of it.
Yes.
And Lordship, paragraph 78, just a small paragraph, I will just, Lordship. Power under 438 CRPC being an extraordinary remedy has to be exercised sparingly, more so in cases of economic offense. Economic offense stand as a different class as they affect the economic fabric of the society. That is, Lordship, will be independent. And Lordship, kindly direct me and come to paragraph 83 for a moment. Grant of anticipatory bail at the stage of investigation may frustrate the investigating agency in interrogating the accused and in collecting the useful information and also the materials which might have been concealed. Success in such interrogation would elude if the accused knows that he is protected by the order of the court. Grant of anticipatory bail, particularly in economic offense, would definitely hamper the effective investigation, having regard to the material said to have been collected by the responsible. So that is my submission, Lordship. Here, he is the head of the institution, Lordship. Everything is at his disposal. And regarding the facts, Lordship, I will just try to replace your Lordship.
No, but what is there to show that he is not cooperating?
Cooperation,
After getting anticipatory bail, he appeared before you.
Whether it is not the custody intervention. Yeah, sorry.
Now the prayer of the prosecution would be to vacate the interim. So you have to show something that he has misused his no, not only misused, either he has misused or his custodial interrogation is necessary. Necessary for the purpose which cannot be achieved otherwise keeping him on in
For 2022 SCC online 1529, that is Sumita Pradeep. I do not have a copy, but I'll just try and read this small paragraph.
What is the citation?
2022 SCC online 1529. This is Sumita Pradeep versus Arun Kumar.
1529. Yes.
Yes, gotcha.
Para?
Para 6.
What it says?
Just comes to the point, Lordship. In many anticipatory bail matters, we have noticed one common argument being canvassed that no custodial interrogation is required for, and therefore anticipatory bail may be granted. There appears to be a serious misconception of law that if no case for custodial interrogation is made out by the prosecution, then that alone would be a good ground to grant anticipatory bail. Custodial interrogation can be one of the relevant aspects to be considered along with other grounds while deciding an application seeking anticipatory bail.
Yes.
There may be many cases in which the custodial interrogation of the accused may not be required, but that does not mean that the prima facie case against the accused should be ignored or overlooked and he should be granted anticipatory bail. The first and foremost thing that the court hearing an anticipatory bail application should consider is the prima facie case put up against the accused. Thereafter, the nature of offense should be looked into along with the severity of the punishment. Custodial interrogation can be one of the grounds to decline anticipatory bail. However, even if custodial interrogation is not required or necessitated by itself, cannot be a ground to grant anticipatory bail. Dear Lordship, this section involved, Lordship has already seen is 3165. 165 Lordship, criminal breach of trust. I'll just give the.
Life imprisonment is.
Yes. Whoever been in any manner entrusted with property or with any dominion over property in his capacity of a public servant or in any way of his business as a banker, merchant, factor, broker, attorney, or agent commits criminal breach of trust in respect of that property shall be punished with imprisonment for life. And Lordship, the Lordship, investigation carried out so far directly points to the involvement of the agent petitioner Lordship. In that regard, there is no doubt. Whatever documents he has produced in the affidavit relates to only one person, Pankaj Goyan, that he sought to file he filed an application for defreezing the account. That was one of the arguments that were advanced before looking. But what about the other 4 persons? They are also, their accounts were also frozen. All those illegal activities.
Those other 4 are also the informant.
Yes, yes,
Wait,
they had also
not
filed. They had filed the complaint Lordship and they have taken the supplementary FIR Lordship. All those cases are involved here only Lordship. I'll point out Lordship, take my comments.
Okay.
So that is also there. What about the 4 persons, other 4? And Lordship will kindly see in this branch, particular branch, all those fraudulent activities are being done Lordship. Within a gap period 4 or 5 months. And not disclosing everything Lordship has already seen that these are technicalities Lordship, and the fact of corporate ID, it has come only after investigation Lordship. It was not stated by him Lordship. It was repeatedly asked everything Lordship. And regarding corporate ID, as I have pointed out Lordship, there has to be a business establishment. Where are those documents? Those documents has not been produced before the IOM. That are not.
But corporate ID was given to this account.
Yes. Otherwise, Lordship, 1 crore transaction cannot be done in a single.
And that can be given by the bank manager.
Yes, branch manager.
Branch manager.
Yes.
And the account holders were petty businessmen. Only one is the.
Rest of 4 business also Lordship. They are 4 people. Lordship.
Okay.
So Lordship will kind of see the gravity of the. And as I pointed out, Lordship, the judgment which I have cited, Lordship will kindly note paragraph 74 and 75 also. Of Lordship.
Sunita.
No. 2019 9 SCC 24.
Chidambaram. Era?
74 Lordship. I may just read 2 lines. Ordinarily, arrest is a part of the process of the investigation intended to secure several purposes. There may be circumstances in which the accused may provide information leading to discovery of material facts and relevant information. Grant of anticipatory bail may hamper the investigation. Pre-arrest bail is to strike a balance between individual rights to personal freedom and the right of the investigating agency to interrogate the accused as to the material so far collected and to collect more information which may lead to recovery of relevant. So, and this also refers to Lordship Anil Sharma case, which I have already pointed out Lordship, regarding custodial information. It is my Lordship, any more queries, you can clarify Lordship.
Okay. You give me the case.
That of the employee Lordship. And if Lordship there is their statement also, every single document, evidence, everything points to the present petitioner. That is my
Okay, I'll go through the case.
Can I add 1 line?
Only 1 line. Because your 1-liners are very long.
The authorities, that Chidambaram, my lord, would have been the best authority while granting pre-arrest bail. Here is a case of I am not paying for pre-arrest bail. Lordship has already, this honorable court has already granted me pre-arrest bail. It is of vacating it, my lord. And the second one, Sidambaram's case is 3,500, 300 foreign investment, my lord. And secondly, my lord, with all respect, my lord, the dominions are different. And regarding the other accounts, my lord, and 1 crore was not deposited in a single day, my lord.
10 lakhs maximum.
10 lakhs, up to 10 lakhs in one day, in many number of days. And my lord, regarding the rest of the accounts, those were also detected by the monitoring authority, my lord, and that is the system in every bank. Monitoring authority, and those were also frozen upon my inquiry, my lord.
54 to 73.
All documents are at 54 to 73 in additional affidavit, my lord.
Okay. Heard Mr. B.K. Mahajan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Let this case be listed for delivery of orders on 8th of August. 8th of August.
Well, only under more than this case, bank exactly tailor-made, my lord. Only we have marked it, my lord. This is, I think I should not do it, my lord. Lordship it peruse it at leisure, my lord.
May mention the paragraph number.
Yes, my lord. Yes, my lord. I will pass it before the, my lord, gentleman present, my lord.
Okay.
My lord.
Please citation will not be file of separate file of the citation.
May I please, your worship, my lord, item number 37, may I pray for a date, my lord, the next week?
Hearing date would be given by registry. We are not in a position to. It will be shown as leftover.
So I didn't have Victor, item number 38, lordship. It says, it's a long pending matter, lordship, since 2020.
No, hearing the, you request before registry. Registry will give the.
I beg to mention item number 35, your lordship. So in item number 35, your lordship, the earlier I was preferred, which was rejected by the different bench of this honorable court, your lordship. So the matter may be listed before the appropriate bench, your lordship.
Okay, item number 34,
Annexure 3 is,
35.
yes, your
Heard, Mr. What is your name?
S.J. Chaudhary.
L.J. Chaudhary, learned counsel for the petitioner submits that the earlier interlocutory application, if one of earlier interlocutory application has been dealt with and rejected by a coordinate bench of this court. And therefore, as per the prevailing notification of the registry, this matter should be taken up, should be listed before the said bench. Stop. Registry to do the needful. Registry.
Please, your lordship. Number 31, criminal appeal. We have the appellant. The appellant wants to withdraw the case, your honor. Lordship.
Item number?
31. He does not wish to proceed further with the proceeding.
Why?
Lordship,
Then we'll take it up tomorrow. Heard, Mr. What is your name?
A. Chetri.
B. Chetri.
A.
A. Chetri. Learned counsel for the appellant, who submits that the appellant wants to withdraw the instant appeal. Stop. As due to paucity of time, this court could not go through the file. List this matter day after tomorrow.
34. He was my member. He was drafted interim, my lord. Sorry, my lord. I was done. That is absolute bail, my lord. I went to the IO, then case is transferred to CID now, my lord. So I filed the IM, my lord. It listed twice, my lord. Did not list, my lord. May it come upon
Date will be fixed, my lord, next week, my lord.
This will come before this court, this bench or it will. Who granted you anticipatory bail?
Your lordship, your
Friday.
item 46 it may come up on 14th, my lord. The Anticipatory bail application. Otherwise, service is awaited, but it's a POXO matter AB. Charge sheet has already been submitted, so in the past, your lordship has directed petitioners in similar cases to approach the trial court. So perhaps that, we are also anticipating.
Okay, when you want?
14th, maybe.
14th. Okay.
Deep blue.